All persons having business before the Honorable Associate Judges, now presiding over the District of Columbia Court of Appeals. Draw near and give your attention. God save the United States and this honorable court. This honorable court is now in the session. Please come to order.
Good morning. We have 3 cases on the morning's calendar. I perhaps should indicate that, as you may know, we had some internet problems this morning that delayed us a little bit. But I'm glad to see we are all able to be logged in. In case you're wondering, Judge Thompson's background differs from our background. This too has a computer glitch explanation, which is not worth going into, but we're all here and ready to proceed. The first case on the calendar is Henry Zuniga and others versus Whiting Turner Contracting Company. Counsel?
Good morning, Your Honor. My name is Matthew B. Kaplan, and I represent the plaintiff's appellants in this case. And with the permission of the court, I'd like to request 4 minutes of rebuttal time.
Mm-hmm.
Your Honor, let me start with one of the most important issues in this case, which is that in our view, the trial court was mistaken when it held that we had essentially waived our right to a supplemental attorney's fees award by not moving for fees within 14 days of the court's May 13th judgment, the trial court's May 13th judgment, reaffirming its February order awarding us fees. As you know, DC Code 321308B sets out a statutory scheme meant to encourage competent counsel to represent wage and hour plaintiffs, plaintiffs who often generally don't have resources to hire attorneys on their own, and often have cases that are relatively, as this case is, are relatively low value cases. And one of the key aspects of that statutory scheme adopted by the DC Council is a provision which says that plaintiffs and their attorneys are entitled to be compensated, not just for the work in the substantive case itself, but they're entitled to attorney's fees if they're reasonably necessary to actually collect on either a judgment or a fee award. But the trial court that is ruling that requests for these such supplemental fees must be made within 14 days of entry of the fee order or the substantive damage order that's being collected upon. That would effectively vitiate the scheme set out in 1308B. Judgments usually aren't paid within 14 days. And in fact, under the DC rules, plaintiffs must wait 14 days before they even attempt to collect on it. They take any enforcement action to collect on a judgment. So the rule that the trial court would have imposed would essentially vitiate the scheme. It would be, as a practical matter, almost always impossible to collect to have a judgment, to be awarded fees for trying to collect a fee award or a substantive judgment.
Counsel, can I ask you about how your view functions? Am I right in thinking that you believe you are still trying to enforce the judgment?
That's absolutely right, Your Honor, and that's one reason. I mean, our view, and this is the view that has been adopted by the federal courts, is that we have a reasonable time after you know what our fees are to request those supplemental fees.
And does that mean that if you're right about that, does that mean that in fact you didn't need to seek, you chose to seek some kind of interim attorney's fees? But if your theory is correct, does that mean that you could have, up to right now, you wouldn't have been required to make any fee request? You could still be just trying to enforce the judgment, and you could be on appeal from an order denying you prejudgment interest with respect to that, and you could file a fee request. You know, if you were to prevail, obviously if you're not a prevailing party, then maybe you'll have some issues, but if you were to prevail on that, then you could file your first fee application relating to your efforts to enforce the judgment. You could have, I know you didn't, but you could have, on remand from a successful appeal relating to post-judgment interest? Is that
That's-
the lot?
That's absolutely 100% right, Judge McLeese. And specifically, the reason we don't think that we've been paid, our clients have been paid what they're owed is, one, interest is owed, and two, under the statute, our fees for collection efforts are also owed. So you're.
Well, the interest, am I right, though, that the only interest that's in dispute is interest on the fee judgment, or am I misunderstanding something? I thought the interest was you got a fee judgment. Is that incorrect?
No, you're right, Your Honor. But that's never been paid. I mean, there
No,
was.
I understand that, but you were talking about your clients never getting what they were owed, as though the interest would be going to your clients. I thought this post-judgment interest was a post-judgment fee award.
You're entirely correct. Yes, Your Honor. I didn't cloud the issue.
It's not clear to me that you are entitled to fees for collecting the interest. It seems to me that the statute may provide for a fee award for efforts to collect the judgment. But I'm not sure that applies to a claim for interest on the judgment if there's a delay, and according to you, it could be a delay as short as 1 day in payment of the judgment. And in this case, really, in that sense, your collection efforts were over by May 15th, when you had gotten the judgment you needed, and the judgment was paid. And I think under those circumstances, I don't see why you waited 135 days or so to file a request for your attorney's fees in essentially securing that judgment. And it seems to me, and I guess I should say too, even if it were true that your collection efforts had not been finished, I wonder whether that isn't a red herring. I don't see why that excuses you from doing something within the 14 days. You have options under Rule 54, or providing the court with good cause for the delay in failing to do something within the 14 days, which you've never done.
Let me address those issues, Judge Schlickman. First of all, the interest, I think interest is an integral part of the judgment. And I do think we're entitled to, until interest that is owed on the judgment is paid, the judgment's not paid. And I think we're entitled to our fees to fully collect on the judgment. You mentioned the possibility of us, moving for fees at an earlier date. Rule 54D requires that, when the motion is made, you set out your fees, or you set out a reasonable estimate of your fees. I don't think we were, certainly under the, the trial court's May order was nunc-pro-tunc to February 12th. And so under the trial court's reasoning, we had 14 days from February 12th, 2019 to file a fee request.
Well, you did file one. You did file a fee request within 14 days of the original order. Or that was actually, that was back in, was that back in September or November? I've forgotten the.
Well, we filed a fee request in following the original judgment.
And you filed that within 14 days.
Of the original judgment, yeah, yes, Your Honor. Which would be, I think, normal in these type of cases, because we would already done our work and we expected.
Right.
The fee.
So similarly, nobody's saying you had to file a fee request for work that you hadn't even known would be necessary or hadn't been done. But once you put in more work and you then get a judgment, in other words, your collection efforts were successful, and now you want fees for those collection efforts. I don't understand why you shouldn't be required to do one of three things, which our cases say: either file something requesting your fees within 15 days, 14 days of the May order, all your work's been done by then. Or if you feel, well, it's not done, we're still in media res, you file something to the judge saying, look, we need more time. The rule provides that you can extend the 14 days. Or at the very least, when you finally do file, make a showing as to, an excuse for not having filed earlier. I mean, our case law says that Rule 54 is to be strictly applied.
I think, starting your last point, I think it's, evident, in our filings and our fee filing is that the reason, our good, to the extent we needed a good cause not to file, the good cause was that we had not completed our fee collection efforts. And I think it was entirely reasonable.
In what sense? On May 15th, you got everything that the judge ordered.
Well, for one thing, Your Honor, we didn't get interest.
You didn't get interest. The interest is what, about $750? Have you calculated what the interest is?
It's about $450 under
$400
regulations for about 92 days.
So the collection efforts associated with collecting that $450, that's what was holding up filing a fee application?
Well, no, Your Honor. What we had done, which I think was entirely reasonable on our part, was we went to the defendants and said we're owed interest and we're owed these additional funds for our collection efforts. And they responded to that by not by paying, but filing a motion with the court, asking the court to judge that we owed nothing further. And I think
even then, you didn't file an application for fees.
Well, again, we didn't think it was appropriate to do so because we hadn't been paid what we were owed, and both in terms of interest and in terms of we were owed additional funds for collecting on our fees.
But you agree you got a judgment in May that ordered that was the culmination of all of your collection efforts up to that time, let's put it that way. And that was paid within 2 days. And that paid you, it sounds like 99% of all your costs and fees.
No, I wouldn't agree with that, Your Honor. We got, as a matter of law, we got a fees order that was effective on February 12th, and there was no reason to think that the May 15th judgment was non pro tunc. There was no reason to think that the May 15th judgment started the 14th.
All right, the percentage, my percentage might be wrong. You're quite right.
Well, not the percentage, Your Honor. I just, in terms of the date, I don't think the May 15th, we were not, there's no reason for us to think that the May 15th judgment started a 14-day clock.
But
Can I
that's
ask you a
what
question about? Can I ask you a question about the what you think the trial court decided in the May non-pro-tunc order? Do you think it resolved in its entirety the enforcement dispute that you'd been having, or do you think instead it resolved one aspect of the dispute but not all?
Judge Marquise, I think the only thing the trial court did in that order is that it corrected what was essentially a technical mistake in the February 12th order. By the law of non-pro-tunc, relating to non-pro-tunc, what the court did is it said, effectively it said we admitted language. I admitted language. The court omitted language in that order that made it clear who.
I know what the court did, and my question is more about how you understand the dispute between the parties up to that point. It might be one thing. I guess there are two scenarios. I guess one would be the parties are fighting about payment of the February fees judgment, and you haven't gotten satisfaction of that yet. And there's a back and forth about how that's going to sort itself out. And if you had gone to the trial court and said, Judge, you need to tell them to pay us, issue an order saying this enforcement is you're failing to comply with the order, and I'm giving you a new order to pay the judgment, like a judgment enforcement order of some kind. That might be one thing, but my question is that what it was, or was it something a little bit different, which was the parties were fighting who knows exactly what all about, in connection with getting the judgment enforced. And there was at least one possible sticking point, which was this, in trying to get garnishment, there was a question about whether the February order imposed joint and several liability. And you went and asked the trial court to sort that out, and the trial court did sort that out, nunc pro tunc. But I'm just trying to figure out whether that order kind of logically resolved the ongoing enforcement dispute in its entirety, or whether it didn't, and it left open still the fight that was going on about whether you were going to get paid for the February judgment.
Your Honor, I would disagree with you to the extent that you're characterizing it as a fight or a dispute. I don't think there was any misunderstanding between the parties to the extent that that February 12th order obligated both defendants.
No, I understand. I don't mean a dispute on the legal merits. I meant you were trying to get them to pay, and from your perspective, they were refusing to pay.
Right. And Your Honor, our understanding was that that fees order was essentially a judgment, and the way you enforce a judgment is you don't go to the court and you don't seek an order from the court. You take enforcement action as is permitted by the law, and that is what we were attempting to do. And to do that, we needed to correct the order, but there was no other relief we needed from the court except to have the order say what we think the court and what the court ultimately ruled it had meant to say.
Put differently, I was just trying to ask, do you think the May order is a new judgment, or do you think it is, not a new judgment? And if there is a judgment from which the clock starts running, the only judgment, if the clock has to run, relative to this dispute, would be the February.
The only judgment in this case, Your Honor, is the February order, and the May order is nunc pro tunc. Its date is February. Any deadline that would run in this case runs from February. And let me just briefly mention that we said a few cases.
Well, I guess that can't quite just to quibble a little bit. That there's also the judgment that you're appealing from, but that was not in your favor. But any judgment that you could have been untimely in seeking fees with respect to, your point is the only one that is actually a judgment is in February, because there was a February judgment and then a May, nunc pro tunc technical adjustment to it. Right.
And again, under the trial court's reasoning, we had 14 days from the February 12th judgment, and that, if that's the law, then effectively this scheme 1308B is very difficult to it is essentially impossible to enforce.
Mr. Kaplan, it would be helpful to me if you could give us the 1-minute summary again of the timeline, because I'm having difficulty now understanding why you thought you were in a position to seek attorney's fees when you finally did do it. You've said that there was nothing that put you on notice that the May 15th ruling started the clock ticking. And obviously at that time, you couldn't reach back in time to 14 days after the February order. So tell me what the relevant dates are in justifying why you waited until you did. So you had, where's the starting point? The February judgment? Well, it wasn't a judgment, the February ruling that needed to be amended nunc pro tunc. So do we start there? And then what?
Well, no, Your Honor, actually, I think the appropriate place to start is when, our collection efforts are completed, and when we're paid what we're owed. And,
well, wherever you think you need to start, give me the 1-minute version of the timeline and the significance of each date. So start wherever you think you need to start.
Well, again, the February 12th order, let me step back for a second. The initial damages judgment was November 17th. We moved, and I think it's clear we were obligated to move, and we did move within 2 weeks of November 17th. And then the court ruled on that and issued its fee judgment on February 12th. And we obviously expected that to be, what solvent defendants normally do. We expected that to be paid, and it wasn't paid. Your question is, when is the deadline for us to file a supplemental fee petition? And
Well, I'm trying to understand the logic of what had happened by the time you actually did come in. Is the number 135 days, as I recall? What had happened by that time that caused you to think now's the time?
well, what had
in
happened
relation
is,
to all these
right,
other dates.
what had happened is that the trial court had had granted defendants' motion, which essentially, I mean, we told defendants, look, we think you owe us more money, both interest and in fees. And defendants attempted to negotiate some kind of payment. And defendants responded by moving affirmatively, knowing that we wanted attorney's fees. They moved affirmatively to the trial court to rule affirmatively that we owed nothing. And that ruling was issued in September of 2019. We responded, and I think Judge McLeese suggested correctly that under our theory, we didn't necessarily have to do this, but we responded sort of to preserve our rights. We wanted to get a fee request before the trial court. So we moved, after the trial court said we were owed nothing, we moved for fees and asked the trial court to reconsider its adjudication that we were owed nothing. But I think, the broader point in our view is that, the federal courts are faced with similar situations, but without the really strong language in 1308B saying that we're entitled to plaintiffs are entitled to supplemental fee awards. I mean, the trial courts have said that it's reasonable to wait to pay until you're paid all that you're owed and then file the fee motion. In fact, federal courts, we've cited a case from Lucero versus Parkinson from the district court in this jurisdiction, where it was months after the fee was very similar to this case, that the defendants knew they were about to be initially refused to pay. There were collection efforts. Defendants knew their assets in the Lucero case were about to be seized, and they paid up to avoid those collection efforts. And then several months later, the plaintiffs filed a supplemental fee request. And the federal courts generally have taken the position that as long as the initial fee request is done within 14 days, the supplemental fee request needs to be done within a reasonable amount of time, that there's no clear, that the 14-day deadline does not apply to that provision. And unless there obviously there's any more questions, I'm happy to answer them, but I see that my
Yeah, I think we'll let us hear from counsel for the appellees, and we'll give you a few minutes in rebuttal.
Thank you. May it please the court, Michael Jack for the appellees, Commercial Interiors and Whiting Turner. The court entered an order at the request of the plaintiffs on May 13 that resolved all issues that were before the court. The only fee petition in existence filed with the court was decided by that judgment. There was nothing after that. There was nothing at that time and nothing done after that. The next filing by the plaintiffs was a motion for attorney's fees on September 25, 135 days later. Superior Court Rule 54 requires fee petitions to be filed within 14 days of the judgment. The judgment was May 13.
Can I ask you, why do you say that the judgment was May 13? The trial court said this judgment is nunc pro tunc to February, whatever the date was in February. So why should we look behind the trial court's characterization of the effect and of its order?
Well, if it were nunc pro tunc and applied religiously in that way, then the time ran from May 13th. Well, that would be the judgment 14 days from then.
No, I don't understand. I don't understand your answer. If it was nunc pro tunc to February, either maybe this suggests that the statute, the time limit doesn't apply, but wouldn't it ordinarily run? I mean, for example, imagine that a trial judge issues a judgment, a final judgment, and somebody files a motion to correct a clerical error. And the trial court grants that motion and says, nunc pro tunc to the date of the final judgment. what do you think is the date of the judgment for purposes of taking a timely appeal?
I would say it has to be the order, the second order. I mean, otherwise the potential appellant, his time to appeal is probably gone. Yeah, I'm under these circumstances, I'm perfectly happy to go with February, because then the time for filing the fee motion was gone by 3 more months. But
No, well, no, not really, because if the answer is February, then your opponent's argument that if the question is, when do you have to seek fees relating to your efforts to enforce a judgment? He's got a good point that those efforts certainly hadn't been completed and couldn't be expected to have been completed 2 weeks after the February order.
I think the law is pretty clear that your efforts don't have to be completed. And I believe the last words out of counsel's mouth during argument were, when he was referring to the law, is that as long as the initial fee petition is filed within 14 days, you can thereafter supplement. I think that may be a correct statement of the law under some circumstances, at least. We'll accept it for the moment. But there was no fee petition filed within 14 days of anything.
So here's a hypothetical. Imagine that instead of reacting to the May order by paying at least the non-interest aspect of the dispute in a couple days, your clients had just continued to refuse to pay. And, Mr. Kaplan had, been continuing efforts and had to, garnish, file garnishing and do all sorts of things to try to actually execute the judgment against your clients. Is your view that Mr. Kaplan would have been required by the May order to have sought fees for what he'd done up to the point of the May nunc-pro-tunc technical correction? And if he didn't, then he's just out of luck, I guess, looking backwards and forwards in terms of his future efforts to enforce the judgment?
Yes.
Is that your view?
Yes. I think it's what the rule very clearly states and what the case law very clearly states. You have to file within 14 days. There are no exceptions under the rule.
Okay, so let me try another example. Imagine a simpler case where a judgment is entered under this statute, and the lawyer for the plaintiff who has secured the judgment waits 14 days to try to start executing it, because you're supposed to wait a while before you start actually executing on the judgment. Asks for payment, doesn't get paid. 3 weeks go by and decides, I'm going to start trying to execute on the judgment. I'm going to try to, locate assets and issue get liens, secure liens and garnish things, and generates a bunch of attorney's fees. Is it your view that all of those efforts are uncompensable because the fee request was required to have been made 14 days after the entry of the underlying judgment?
Probably yes. However, I would point out those are not the facts of this case. As of May 14, in this case, if you look at
I'm well aware those aren't the facts of this case, but on the other half of it, that seems to fly in the face of a statute. So, applying the attorney's fees rule in that way does seem to fly in the face of a statute, which seems to express, particular solicitude for allowing attorneys to recover fees accrued in trying to enforce a judgment.
Well, I'm not sure how solicitous or how much solicitude there is in the statute. Go by the words of the statute, I would submit, as opposed to
right. The words of the statute say, you're entitled to fees in trying to enforce a judgment, and the rule that you're relying on says, unless the statute provides otherwise, you need to file within 14 days. And your opponent's argument is the way that fits together. I mean, this case is more complex than the hypothetical I'm giving you, but I'm just trying to make sure I understand your view about the relationship between the statute and the rule. And it sounds like you're taking the view that the statute, the rule trumps the statute, so that any under the statutory provision, under claim that arises and a judgment that arises under the statute, any post-judgment efforts to enforce the judgment, any fees related to that cannot be accrued unless they're requested within 14 days of the underlying judgment. And that seems hard. How does that make sense?
Unless a fee request is initially filed within 14 days.
How do you make a request for something you have to put a placeholder in and you say, I'm not sure whether I'm going to have trouble enforcing this judgment. I haven't tried yet. But by the way, if I do, I'm requesting what I'm entitled to under the statute, which is such reasonable fees as I incur in trying to enforce it.
I don't know. Those are not the facts of this case. The facts of this case are.
Right, I'm really not asking about the facts of the case. I'm trying to ask you about how the statute and the rule are interpreted together.
Well, I think it's difficult to go up in the hypothetical divorce from the facts of the case, because what the facts are matters. Obviously, we ought to be making law or interpreting law, applying law based on the facts before us. And the facts before us are that as of May 14, according to the fee petition that was filed in September, the plaintiffs claimed to have had incurred fees prior to that date. So as of May 14, they had fees, at least purportedly, that they had incurred and could have claimed, and the rule required that they do so. That's the and there's no except the rule says unless statute provides otherwise. I do not see anywhere in the statute where the statute says otherwise, where it contradicts the dictate of the rule. We have the case of Escamilla out of the district court in DC applying the identical federal rule that says 14 days means 14 days, and if you don't get it, you're out.
Actually, Rule 4, I believe Rule 54 is a little bit more flexible than that. The way the federal courts have interpreted it, there is the option. The rule is flexible because it provides that the court may order a different time limit, and it's not jurisdictional. And so, for good cause shown, the party can come in after 14 days and get attorney's fees. I think the problem here may be that good cause hasn't been shown, because the collection efforts were essentially completed as of May 15th, and an order issued. It's not just a judgment, it's whether it's a non-protunct judgment or not. It doesn't really matter that much because it's an order, it's a decree. And there doesn't seem to be any reason to have waited 135 days to file a fee request. For work that was done, this doesn't apply to the request for interest, but for work that was done and successfully as of May 15th.
Can I ask you a question that follows up on Judge Glickman's about the request? There's obviously a dispute not only about enforcement of the February order, the February fee judgment, and the later May technical correction non-protunct of that judgment, but also about interest. And that fight is still going on about whether your opponent is entitled to interest, and if so, measured from what date, February or May. Do you agree that your opponent would ultimately be entitled to fees if they prevail in that? Or do you think, again, if I understood one of your positions, it is kind of the May judgment ended this case. And unless you made a fee request within 14 days of it, doesn't matter what else is going on. Attorney's fees are out of the picture, including any further fees about the dispute about interest, even if your opponent prevails. Am I right in understanding your position?
I think that's correct. Certainly what the Superior Court held, and I think correctly so.
Well, I thought that the Superior Court held about interest, that the issue hadn't really been adequately presented on the merits to it. And so I don't know that it had to really get into the question of fees on efforts to recover interest, because Mr. Kaplan was not the prevailing party with respect to the efforts to try to recover interest.
I don't disagree with that characterization. I mean, the Superior Court finally held that considered the case over, considered the case of May 14. When the fees awarded were paid, the judgment having already been paid long before that we were done. That's why it's stated more clearly in granting the motion to enforce it. Completely said, defendants have done everything they were ordered to do under the judgment, and they're done.
Can you answer a question that I couldn't see explained in your brief? and I want you to limit yourself to the record. What does the record show about why your clients didn't pay the February judgment until after the May order? What does the record show about the reasons for that failure of payment?
I don't know that the record shows much one way or the other than there was shortly after the entry of the May order, a motion by the other side to amend that order, which made that not a final order as far as we were concerned. And I think not just as far as we're concerned, I think legally it was not a final order at that point until that motion was decided.
Well, your opponents allege that during the period from February to May, your clients were demanding information that they believed was irrelevant and inappropriate. Is it correct that as far as there's no, I couldn't find any indication in the record that your clients ever responded to those claims or that you pointed to anything in the record that would bear on whether those are fair assertions or accurate assertions or inaccurate assertions. Is that right?
My recollection is that there's nothing in the record that supports those accusations. But those accusations are baseless, which is what I read the Supreme Court as having.
Well, that's I guess what you mean. Nothing that you mean that they were asserted in filings and then no issue of proof ever arose. Is that? But were they disputed by your client in the trial court? Those assertions? Is there any statement in your?
They're not true.
Well, I was asking you to confine yourself to the record, so I hope you will. So my question is, was there any statement by your client in the record in the trial court disputing those assertions?
The court will forgive me. I'm not positive those assertions were in the record before the trial court. They're being made here on this appeal, but there are a number of things being asserted on this appeal that were not presented to the trial court. And I think those are one among them. The issue was they filed a motion that made the order for attorney's fees not final. We paid it at the instant it became final. Their motion kept it from being final.
Wait, I don't understand. It was final. I thought it was final at the time it was issued in February.
They then filed a motion.
When did they file that motion?
April 10.
So what's the explanation for the failure to pay between February and April?
A motion to do what on April 10th?
A motion to modify the February order. To amend the order, motion to amend.
And was there an explanation in the record for why there was no payment between February and April?
I don't know that there was.
And why do you say that a motion to modify a final judgment makes the judgment not final?
That's my understanding of the way it works. I certainly think if we're roles reversed and were we dealing with time to appeal, that would be the position. I think the rule is I understand the rule to be pretty clear that a motion.
What rule are you referring to?
That would be Rule 60, I suppose.
Well, a Rule 60B motion definitely doesn't make just the filing of a motion doesn't make a final order non-final. There are some rules about timeliness for notice of appeal and certain motions like Rule 59 motions and Rule 60 motions if filed within a certain period of time of judgment can render the notice of appeal, can give you more time to appeal. Whether they render, I doubt they render the judgment non-final for purposes of enforcement, for example. So you think that if I have an order requiring your client to pay X amount of dollars and somebody files a motion to modify it, you think that the motion automatically stays whether the judgment is enforceable?
Well, I think it depends whether it's Rule 59 or Rule 60, as I understand it. However, this flies right.
Well, actually, under either of them, do you think that the mere filing of a motion to modify, even if it would toll the time period, renders a final judgment unenforceable? Like automatically stays it?
That is my understanding that under at least one of the rules, not under 60, but under 59. But consider the logic of the circle that this posits. If the filing of the motion did not make the February 13 which was the order, which was a final order under, as the court is positing, then the time for everything ran from February 13th.
Unless a statute says otherwise.
Which, as we've discussed, I think very clearly does not.
So going back to Judge McLeese's question, was your answer that there's nothing in the record that explains why your clients didn't pay between February and the date of that April motion? Was that your answer?
I think that was the answer, and I think that is accurate. I would have to check the, let's see. Any response, the response would be in to the contention, would be, I suppose, in the motion to enforce and the opposition to the motion for attorney's fees, all of which were in September. So whatever those say is what's the record. That is the record on both sides. As I say, I don't believe that, my recollection is that the accusations as to what was going on were not presented to the by the plaintiffs, were not presented to the Superior Court, and therefore I don't know that we had a whole lot of cause to be explaining why we were doing or we weren't doing what we weren't then being accused of doing, but now. I'm not sure where I am on my time.
Well, I think you're over your time.
Okay.
I'll let you wrap up if you want.
All right. I appreciate that very much, Your Honor. Just very briefly, this case has been going on for 3 years. It should have been over in 2.5 at most, as the Superior Court pretty clearly stated. I've asked the court to affirm the decision of the Superior Court. It is 100% correct on the facts and on the law. Thank you.
Thank you. Mr. Kaplan, I think you requested 4 minutes or so of rebuttal time.
Yes, thank you, Your Honor. Let me make a couple of points. One is, I think, the importance of the issue of interest in this case. And, you know, our view is that a judgment is not satisfied until all the interest associated with that judgment is paid. And consequently, the judgments in this case are still not satisfied. And it's not reasonable for us to require us to submit a fees request to collect a judgment when the judgment hasn't been paid. And I think Judge Glickman, you made the point that the interest is not, it's a relatively small amount, but it is, it's an amount, it's owed. And certainly defendants, if they had tendered that amount in interest, which they were entirely free to do, we would not be here, at least this aspect of our argument, we could not.
Correct me if I'm wrong, by the way. When you say a judgment is not satisfied until all interest is paid, the Superior Court issued an order saying the judgment in this case was satisfied, granted the motion of the appellees. Has that order been appealed? I don't know that I see that you have appealed from that order. Am I wrong about that?
Yes, Your Honor. That is in notice of appeal, and we move for reconsideration of that order, and that order deciding that the judgment has been paid is subject of this appeal. And the order itself, the judgment itself, refers to you've got to pay so much in damages plus attorney's fees determined by the court. Since all fees have not been paid, our view is that even the substantive judgment has not been satisfied, and the trial court was incorrect in in making that in making that ruling. One other thing I want to clarify, and I may have not done the best of jobs in answering Judge Thompson's question, and you raised the issue of good cause, Judge Glickman. I want to be clear about what happened here is, we were paid without interest and without the, collection costs on May 15th. We didn't say May 15th, 2019. We did not think that that was full payment. And I don't think there's any reasonable interpretation. The rule doesn't say that you have 14 days of when you're, I don't think you can interpret the rule as saying you got 14 days from when you're paid to file a fees motion. So we didn't think, any 14-day clock was running at that time. But we had told defendants that we, if they didn't pay us, we would ask the court to rule on whether we were owed additional attorney's fees. And the defendants responded, as I guess they were entitled to do, responded by going to the court and making the motion that you were referring to, that asking the court to say that everything paid was owed, that affirmatively asking the court to rule that no attorney's fees were owed. And the court ultimately ruled that way. But to the extent we need to show good cause, I think we had, it made sense for us not to file a specific fees motion, detailing all our fees, while the issue of fees was before the court from June, when that motion was made, until September, when the court ruled on the motion. The court ruled we were not entitled to fees. And
when was the first time you ever raised to the court the question of interest not having been paid and owed?
I believe it was in our, in fact, I'm sure it was in our opposition to the defendant's June motion. We made the argument that we were owed both fees for our collection efforts and that interest had not been paid. I will note.
While we're asking whether or when you made points in the trial court, in this court, you have argued on behalf of your clients that during the period between February and May, the appellees were refusing to pay and were refusing to pay for no legitimate reason. And in fact, were coupling their refusal to pay with what you're viewing as inappropriate, unwarranted, irrelevant requests.
Right.
Is that a claim that you presented to the trial court, or is it, as your opponent suggests, a set of points that you have been making for the first time in this court?
No, and respectfully opposing counsel's mistaken. I mean, we made that exact point to the trial court, that they seem to be trying to. I mean, in our view, I don't know what the actual motivation, but from our perspective, it seemed they were trying to extort from us the addresses of for whatever reason, the addresses of our clients prior to paying. So that very much.
Was that in your opposition? When did that come? Was that in your opposition to the motion, their June motion, or yes? And is it correct or not? What do you know about what the record shows about whether appellees contested those assertions or disputed them or responded to them in any way in connection in any response that they may have filed to your opposition to the June motion?
The defendants have never. There's nothing on the record, and actually I don't know if there's anything outside the record that I'm aware of, but there's nothing on the record. There's no explanation on the record as to why defendants refused to pay. They didn't take. As you know, we characterized it both in the trial court and in this court as as a deliberate, intentional refusal to pay, and there's no explanation of why that is, and I don't know why it is. It's the speculation presented in our brief, and as a matter of law, I don't know that it makes that much difference, except that it was not some inadvertence or mistake. And I would note it's not just a refusal to pay. If defendants had told us on in March, or that yes, we're going to pay, we got to get the money together, something like that, that would have been we would have acted reasonably, and we would not have been here. Let me just touch briefly on, they mentioned the Escamilla case, and the Escamilla case is a case where the initial fee motion, that's a federal case, the initial fee motion was not filed within, or maybe I may be mistaken, maybe it's in this jurisdiction, but in Escamilla, the initial fee motion was not filed within 14 days. And, you know, that's not what happened here. But as we said, what the federal jurisprudence says is that the initial fee motion must be filed within 14 days of the actual substantive merits judgment. But if you're entitled to a supplemental fee motion, you can file that at a reasonable time. And in our view, we've done that. We could still, as you said, Judge McLeese, we don't think a reasonable time has expired. Don't think we were obligated to file the fee petition we filed.
Can I ask you just to make sure I understand your side of the position again? Assume that the trial court had ruled differently and had in the order at issue, and it said, you know, now that we're in the middle of this dispute, here's what I think is owed relative, you know, the X amount of interest is owed and X amount of, there is an obligation for fees. You think that too wouldn't really have started running any clock, at least to the relative to fees that you generated to try to secure that order, because all of it would still be continuing to run until there actually was satisfaction of whatever that new judgment would be. So really, and not even, I mean, I guess it would be within a reasonable time of your getting satisfaction of the full judgment. So no matter how many judgments there are, the clock in your view, with respect to efforts to enforce a judgment, really never runs from any judgment. It only runs from a reasonable time from the end of efforts to enforce the judgment. Is that a correct way of understanding how you think the rule and the statute fit together?
I think that's correct, but I think clearly the trial court would have discretion to set time limits and to establish an orderly process so it didn't go on forever. And I think as a practical matter, you know, we wouldn't want it to go on forever. I think reasonableness is the touchstone, and you know, the trial court is fully capable of sort of governing, setting specific dates around it.
Is it your claim that but for the interest issue, you would have filed for attorney's fees within 14 days of the May 13th order?
No, again, when the May 13th, to be clear, when the May 13th order was issued, Your Honor, we had no, it wasn't at all clear.
Well, 2 days later, you got everything ordered. So, all right.
Right.
So,
but we didn't know that.
Well, I understand. So but you knew it 2 days later. So are you saying that but for the dispute over the interest not having been paid on the February judgment, you would have had to, do you agree that you would have had to pay, you would have had to file for your collection fees within, by the end of May, let's call it?
No, I think we had no reason to think a 14-day clock would have started running either on May 13th or May 15th. I don't think it did start to run. I think we had a reason.
See, that's what puzzles me, because the way I've conceived of this, let's put aside the interest dispute for a minute. The way I've conceived of it, obviously you can't be required to apply for fees before you've ever incurred those fees, before you even have an inkling that you know you're going to have to incur those fees. Okay, so the statute has to be interpreted and the rule has to be interpreted. And this, I think, is how federal courts have interpreted them, with that recognition. And when you take steps to collect, at some point, you realize, okay, we're in a proceeding now. When you get a ruling on that proceeding, you have 15 days in your favor.
Mhm.
You have 14 days, presumptively, to file for the fees that you incur to get that ruling. And so I would have thought that if it weren't for the attorney's fees here, and you get those collection fees, you're entitled to collect to get those collection fees by virtue of the wage statute, which specifically provides for it. Okay, but there is a rule that says here's the time mechanism under which you have to apply for those things. You can't wait forever. So I would have thought that if we didn't have this question of the interest that we're all talking about, you would be in a position of having to agree that you made these collection efforts between February and May. They were successful as of the middle of May. You got the judgment you wanted, and you actually got the amount of the judgment. And at that time, you hadn't asked for interest, and you hadn't let the judge know that you expected there to be interest running from February to May. You just said, make this, correct that ruling. So you got the judgment you wanted, and I would have thought you would agree that within 14 days, by the end of May, if you want to have a little room because of the 2-day period in which between the judgment and when it was paid, that would be the time period that you'd be required to submit the fee application. What's wrong with that thinking?
Well, first of all, on the interest, I think you mentioned, Your Honor, we didn't ask for interest. I don't think we were in a position to ask for interest. I think our view is that interest, as a matter of law, automatically.
I understand that. And
which is why we didn't raise it with the trial court. And as to your position, your point, I think after we were paid on May 15th, it's quite true. We had a reasonable period of time to seek our fees. I don't think there's any way you can interpret the rule that says once you're paid May 15th, you've got 14 days, or it couldn't have run from the May 13th order because that was a nunc-pro-tunc order. And also we didn't know if we would be paid. So I think once we had been paid that, if you set aside, as you did in your hypothetical, you set aside the interest, I think we had a reasonable time.
Well, the rule says presumptively, the way I read the rule is presumptively the reasonable time period is 14 days from the judgment. Now you can go to the judge and say, Judge, we need a little more time. The rule contemplates that if you have good cause for a delay, the rule seems to permit that, especially as it's been interpreted. But I would have thought your starting point, just as it was when you applied for fees on the original award, would have been to get your application in within 14 days.
Well, again, Your Honor, the order was effectively February 12th, and that's why we did not think that.
But that's a matter of form. The point is that what you were seeking in that order is to get a situation where you were going to get get paid, and the judge granted you the relief you requested, gave you that order. It was paid within a couple of days. You had no further collection efforts to go through, leaving aside the question of interest. To look at this in real terms rather than formalistic terms, I have difficulty understanding why you wouldn't agree that, under Rule 54D, you have 14 days to file an application for the fees that you expended to get that judgment and to get the collection, to get your collection. And then I would have thought you would have said, and Judge, there's a dispute among the parties as to whether there's interest running on this. The interest is a few $100s. Could you resolve that dispute, which the judge wasn't asked to do until much later?
Your Honor, I guess in our view, and I do think the court should look at this in practical terms. And what was happening after we got paid on May 15th, and we did not think there was, and I think we're quite reasonably did not think we had any specific deadline in terms of number of days applying to us running. But what we did is we tried, and I think it's what's encouraged in these type of cases, is we went to opposing counsel and tried to, we owed this money and tried to work something out. And they responded by affirmatively raising the issue with the court. And so that issue was by earlier mid-June before the court, whether or not we were owed attorney's fees within less than 30 days. I mean, that's more than 14 days. But federal courts have allowed gaps.
I'm not sure what you mean by whether or not you're. I'm losing you on one thing. I thought that by May 15th,
Right.
your collection fees were paid.
Except for interest, yes, that's the initial fee award was, to be clear, the initial fee award was paid by May
The fee-
15th.
I misspoke. The fee award was paid.
Right.
And so you had no further collection efforts to make for that award.
Right, but we were still entitled to additional fees for collecting what we had incurred, what we're here for now. We were entitled to fees for
You're going
collecting.
further. So in other words, you're entitled to collect, you think, so in other words, you're arguing you were entitled to continue incurring fees to collect the fees that you were entitled to for collecting the, I wonder if this is right. Could this be right? I mean, this could go on forever.
Well, and as I said, I think in response to Judge McLeod's question, the trial court can govern it and set limits, and I think we got to be reasonable and practical about it. But we were owed additional fees. We didn't have any timeline running. The issue was brought by the defendants to the court as to whether or not we were owed fees. Again, I think, if we'd waited, 3 months, we probably would have forfeited, if it hadn't been brought to the court's attention for a number of months, maybe we would have, we couldn't have waited forever is the point. We had needed to wait a reasonable period of time. But our view, there was no 14-day time limit because that would be inconsistent with the scheme set out in 1308B. And, we did move with reasonable diligence. And the issue was before the court, whether or not we're entitled to fees. The court was deciding that. It decided that we were not entitled to fees. And, in our view, that was a mistake. But we don't think there was a 14-day time limit running from.
Well, can I ask you a further question then? What I hear you saying is the issue of whether you were entitled to collection fees
Mhm.
was brought to the court when the defendants filed in June, I think it was,
Mhm.
for an
Intent.
order saying that the judgment was fully satisfied.
Right.
But even then, although you opposed that order, you did not file an application for any fees. You still waited until September to do that. Does that hurt your position?
No, I don't think so. I think it would have been it wouldn't have been productive to file a fee request. And for one thing, if we had prevailed upon that, and the court had said we were entitled to fees, we would have asked for fees for litigating the motion the court was deciding. So I think it would have been, it wouldn't have been an efficient use of anyone's resources for us to, I think it made sense for the court to decide whether we're entitled to fees or not. And then, we would have submitted, we told the court we would submit a specific fee request at that time. But again, we were in the middle of litigating it. So how could we have set out for the court what that fee request would have been? The point I think from our perspective is that we acted with reasonable diligence to preserve our rights in a matter that was consistent with the scheme set out in 1308B.
Can I ask you a question about interest? I want to be sure that I understand exactly what interest or interest for what period is an issue, because your opponent said something in his brief about the method for determining attorney's fees, the Lodestar method and all, having built into it some inflation and therefore you need no interest. And I'm trying to figure out whether that really applies here, because I had thought that was a point that might lead one to the conclusion that the February fee award was enough without interest from the date the attorney's fee work was done, because there is some built-in amount for inflation. But that's not what we're talking about, is it? It's interest for what period?
Your Honor,
That's a dispute.
yes, Your Honor, the interest is what accumulated from, and I don't think this case is different from any other case. There was an award, effectively a judgment, a fee award on February. The legal date was February 12th,
Right.
2019.
And we're talking about interest from that date to some. future
Right, that
date.
92-day period.
Right.
Where interest was not paid or was not, was never, I mean, again, it could have been voluntarily tendered, and this would have made our argument much more difficult or impossible on this point. But it was not. The defendants took the position take the position in the brief that for some reason, even though we have this very plaintiff-friendly fee shifting scheme in 1308B, for some reason, they think that there's a special rule on interest, that you don't get interest on these fee awards. And I don't think there's any, they don't cite any case law for that. And I don't think that makes any sense. And I think, the interest is important because setting aside all the other issues, just the interest alone, we haven't paid the interest and the judgment hasn't been satisfied, which means our collection efforts have not been completed. And, Judge Glickman mentioned that we didn't raise this with the trial judge, but I don't think there's no reason to do that. The interest runs, you have a right to interest. Interest runs under the statute, it runs automatically. And you don't know what that interest is until a judgment is actually paid. So
Can I ask you just to clarify, when you opposed the June motion, did you mention post-judgment interest as part of why the judge should refuse to grant the motion to rule that you had already received all you were entitled to under the judgment?
yes, sure.
That's what I thought. So you did raise it with the trial court. It's just a question of when.
You're right.
you felt you
You're
were- you
remembering the
felt you were
record a little bit better than I have, frankly. You're right.
Okay.
Yes, we did raise it, and that was one of the reasons we explained why the judgment still remained unpaid. Obviously, if there's any further questions, I'm happy to address them, but otherwise, I thank you very much, and I appreciate the court's attention to this case.
Okay, counsel, thank you both.
Thank you.
Case is now submitted, and the two of you may log off.
Thank you.
The next case on our calendar is Mark Widishek versus District of Columbia. And let's see, we're waiting to see counsel. Okay. Good. Counsel, I've called your case and you may proceed.
Yes, Your Honor, I'm not sure exactly why I'm not being seen.
Is that Mr. McEachin speaking?
Yes, I apologize. I was waiting in the breakout room and suddenly the screen popped on, but I'm not present for some reason.
Have you stopped your video?
No, the stop video the video is running. My
Okay.
mute is off. We went through this a little bit before we started to make sure that everything was fine. And I'm not exactly sure why I'm not being shown. I know Mr. Brandon helped me this morning and we were all set. If I could figure out why.
Well, let's give you a minute to see if you
Okay,
can do that.
give me just a moment, just a moment. Nope, what is going on? I do apologize, Your Honors. I don't know exactly what the problem is. If Mr. Brandon is somehow available, I'm trying to figure out why I'm not being seen.
Let's see, let me ask the courtroom clerk, are you able to assist us?
Yeah, Judge Glickman, I'm not sure what's going on either. Let me see. I'm trying.
This is Mr. Fine. I'm arguing the Fourth Amendment issue. Can you see me?
Yes, we can see you.
Okay,
And
thanks. Just
Mr.
wondered.
Martirano, we can see you too.
Wonderful, thank you.
Hopefully hear you. So you and Mr. McEachin were planning to divide up your argument?
Yes, Your Honor.
Yeah, Judge Glickman, I'm not sure what's going on with the other appellant, Howard.
Would you like me to log back off and log on?
I was about to suggest, why don't you try?
I'll log
Mr.
off
McEachin
at this
logging
moment, Your
off
Honor.
And then logging back in.
Thank you, sir. I do apologize.
Your Honor, you want to go to the breakout room while he does that?
Excuse me, I didn't catch that.
Judge Glickman, I said, let me send your honors back to the breakout room and wait for him to log back in.
Okay, that's a good idea. And then
Okay.
you'll call us back into the courtroom when.
But wait a minute. Wait a minute. I think he's here already. Wait a minute. Okay, he's here. It didn't take that long. Hopefully he'll be able to show up. There we go. Okay. All right.
Okay, Mr. McEachin, we see you now,
Okay.
and we can't hear you because you're on mute.
Uh,
Now we can hear you.
okay. All right then. Good morning, Your Honors. A dubious beginning, but good morning, Your Honors. What we had planned to do with my co-counsel is that we were going to divide the time. I was going to have a brief history of what brings us here. Then I was going to speak on the issue of the correct legal standard to be applied in this case. And then Mr. Fine was going to speak on the Fourth Amendment issues, if that's all right with the court.
And given that it's a little unusual, but given that you have 15 minutes, how do you want to break that up?
The way we would want to break it up actually is I was going to have a brief introduction and then Mr. Fine would go.
How much time should we hold you each to?
Oh,
Roughly speaking.
I'm sorry. No. We're going to reserve 2 minutes for rebuttal, and I was going to speak for six and a half minutes, and Mr. Fine was going to speak for the same amount of time.
Sounds good.
Okay. All right. With that, I'll begin, sirs. Sir, in matter. Good morning. May it please the court. Howard McCann on behalf of appellant Mark Witteshek. As I said, just a brief history of this case. The Office of Attorney General began prosecution of Mr. Witteshek in a civil protection order case in 2012. That was followed by an unlawful ammunition. That case was that CPO was denied. The Office of Attorney General again prosecuted him for unlawful ammunition after that, and that case was eventually dismissed. In 2014, April of 2014, a criminal investigation was launched by the Office of Tax and Revenue concerning Mr. Witteshek's taxes. The relevant tax years for this purpose are 2011 and 2012 in the District of Columbia. A criminal investigation was the first step. There was not a civil remedy actually sought at the very beginning of that. But all along, Mr. Witteshek was responsive to OTR. He had another attorney at the time who he spoke with OTR on April 1st of 2014. Then he prepared a lengthy memo with that attorney, and that attorney went and met with OTR after that. It was their desire to go forward with a prosecution that's lasted, that started over 7 years ago, a very costly prosecution for what ended up being in tax years 2011 and 2012, a total of $56,000 before taxes and penalties. With this, and Mr. Fine will address this, there were a multitude of summonses going into very personal areas of Mr. Witteshek's life that were issued, and Mr. Fine will address that. Mr. Witteshek is a 60-year-old man with no criminal history before these cases. And he has since left the jurisdiction and gone back to New Hampshire, where he's a lifelong resident, and he resides there today. And so with that, I would like to address the issue of the correct legal standard for the court to apply in this case. And I will start by referencing the case of Cheek versus United States. In Cheek, the court held that a good faith misunderstanding of the law or a good faith belief that one is not violating the law negates willfulness. And that's whether or not that belief or misunderstanding is objectively reasonable. What the court did is it further gave us a reason for why it is that the holding is such. And what they stated in that case is that it is the complexity of tax laws which are at issue. And the goal of Cheek was never to criminalize the conduct of a taxpayer who simply didn't understand how to correctly prepare their taxes.
I take it that where you're going is that you're going to claim that the trial judge did not apply Cheek correctly.
Correct, sir.
Maybe that's what you really want to focus on.
Okay. With regard to Cheek, there are two different ways in which there was a standard that was not applicable to Mr. Witteshek. First, the trial judge said that Mr. Witteshek should have known how to consult someone in the preparation of his taxes. That
Can I ask you
methodology.
a question? Can I ask
Yes,
you a
yes.
question about your point here?
Yes.
Because do you think that cheek means that it is irrelevant to a fact finder? No fact finder can treat as relevant whether the fact finder thinks that the claim of a defendant in a tax case is unreasonable. Do you think, because there's a question of what the standard is, but there's also a question of what's reasonable. And if do you think a fact finder can say in a tax case where the defendant says, I thought the following, and can the judge as a fact finder in a bench trial, or the jury as a fact finder, that we wouldn't always know what the jury was thinking,
Yes.
can the fact finder say, that just doesn't seem reasonable to me, and so I don't believe it? Do you think cheek makes the reasonableness or not of the taxpayer's defense irrelevant, so a fact finder can't refer to it and rely on it to a degree? Or do you think it only means that that's not the standard and the fact finder has to do more than just say, this was, I don't think this was a reasonable view?
Well, I think Cheek does make clear that the reasonableness, the more unreasonable the court could find something, that could lead to them determining that's not a good faith understanding. But I do think that what the court has to look at, because this is a specific intent crime, is there a good faith belief? And then we have to do what is not quite as normal, because we often deal with a reasonable person standard, and reasonableness is the touchstone of a lot of things that we do in evaluating things, but go to something which is not as natural and say, if this person believes this, and honestly believes this, then that has to carry the day. So I'm not saying that reasonableness would never factor in, but it does not trump the issue of the specific intent.
Right, and the reason I ask my questions is that to the extent you point to places in the transcript where the trial court, in explaining its verdict, said, well, I just don't think that's reasonable. I think he should have known X. I think he should have known Y. Just those, in light of what you just said about Cheek, the fact that there are those references by themselves doesn't seem to indicate that the trial court did anything wrong. Where what you, I think, may need is something more than that, where the judge says, here's what I think the ultimate issue is for me. Was this reasonable? I don't think it was reasonable. Therefore, I think he's guilty. What would you point to as the places in the record where you think the judge not only relied on reasonableness, as you acknowledge something that can be done, but thought it was the ultimate standard and therefore didn't follow Cheek?
I hope this answers your question. I'm trying to. What I would say is that I believe that what the court did was, in imposing a higher standard to Mr. Witteshek because of his occupation as a certified financial planner, that led to the conclusion that his actions were unreasonable and not in good faith, because there's a higher standard to the actions that the court looked at. So when the court looks at whether or not he should have consulted with someone about this, then what the court is doing is they're putting him to a higher standard. I think that goes part and parcel with whether or not you think something is reasonable. Something is reasonable for one person may not be reasonable for another person based on how you view those two people. And I don't think
that seems less an argument about that the trial court didn't understand the right standard overall, and more an argument that the trial court gave undue weight in determining whether your client acted on the basis of a good faith belief to a particular circumstance. So in other words, if the trial court had said, I understand, as the trial court did in some places, I understand that the issue is whether your client had a good faith belief in the accuracy of what he stated in his tax returns. I don't think he did. And the reason I don't think he did, among the reasons, is he's a sophisticated business person. He's had training in the area of tax, and he knows to consult lawyers when he needs to, and a bunch of other things. But one of the reasons is, he should know. That's not misunderstanding the overall standard. It might be, maybe it's giving undue weight to a consideration, but I'm not quite sure why you suggest that's applying an incorrect, failing to understand that the requirement of willfulness means that the trial judge had to find bad faith.
Well, there is in the judge's verdict, she does mention specifically when getting to the TurboTax defense, her first statement about that is that she finds a TurboTax defense unreasonable. And I say that, and I certainly understand what Your Honor has said before about factoring in reasonableness. But I think it's important when we use phrases like, because again, I think it's not the natural thing to do to be able to distinguish between good faith and reasonableness and to come back to reasonableness. I think that in her ruling, when she begins, it's later on the ruling, I think it's page 27, if I'm not mistaken, but of the transcript. But in any event, what is said is that the TurboTax defense is unreasonable. Then it goes into speaking of good faith. And I think that when you look at how it is that she's analyzing it, you're analyzing two different concepts at the same time. And that's where I think that there's a misapplication of the correct standard.
I think the problem for your argument is that while the trial court did say what she said about the TurboTax defense and used the word unreasonable in another context as well, she ultimately concluded that she just didn't believe that your client truly believed what he claimed about his thinking that he was not a resident or not domiciled in the District of Columbia. And she focused on other things. For example, what she said about his efforts to hide income and evade tax with respect to the LLC that's involved and mentioned in the record. Her discussion of the request made of the hotel in New Hampshire. So it had seemed to me, reviewing the record, that even if the trial court misunderstood the Cheek standard, and I'm not sure she did, but even if she did, I wonder if it was not a harmless error, because it seems pretty plain that she simply did not credit your client's claim that he truly believed that he need not treat his income as having been earned while he was a resident of the district or domiciled in the district. What's your response to that?
I would respond this way. I think that when the judge spoke about those issues, she came back to say, with regard to not believing him, she focused more than once on $98,000 in professional legal fees and his ability to be able to consult with somebody. And I think, and I do understand what you're saying about the Cheek standard. When trying to answer your question now, I think that certainly there's no evidence in this record which allows the judge to place Mr. Witteshek at a higher level than the average taxpayer. The evidence in the case does not bear that out. It does not bear out that he has specific legal training, which is a certified financial planner, uniquely qualified him to be able to complete his taxes correctly. And I think that when you say that she just didn't believe him, I think part of why she didn't believe him, which I think you can look at the record, is that she imputed a different standard to Mr. Witteshek, that she may have believed this from somebody who was an average citizen, an average taxpayer. But that's not what.
I think we want to hear from I think we want to hear from Mr. Fine. But
okay, I was just responding. That's all.
Let me just ask. I take it you would agree that if the judge saw and pointed to evidence of fabrications and misstatements and contradictions of testimony and the like throughout Mr. Witteshek's presentation of the question of where he was living and when he was living there, that would go not to an ordinary taxpayer's difficulty with the understanding of the complexity of the tax laws. It would be evidence tending to prove the absence of a good faith belief. You would agree with that, I assume.
I would agree that, yes, that the judge made that particular determination. Yes, I would agree with that. I would agree.
And you would agree that the judge relied on that in her frequent invocation of Cheek's and the willfulness, good faith belief standard.
Well, again, I think that in relying in Cheek, that Cheek talks about an average taxpayer. So I think in relying in Cheek,
even the average taxpayer, if you catch the average taxpayer in all sorts of fabrications, misstatements, impeachments, and the like,
Yes.
pertaining to the relevant matter, you could say the average taxpayer is showing signs of something less than a good faith belief in the righteousness of his position.
Yes, that would, yes. I would
Let us
agree.
hear from Mr. Fine, if we could, on the what I'll call the Carpenter issue.
Yes, thank you, Your Honor. Yes, this is Bruce Fine, and I'm representing Mr. Wittishek, the appellant in this particular case, and I'd like to reserve 2 minutes of rebuttal approximately. This case is a very narrow case under the Fourth Amendment. It does not require, in the aftermath of Carpenter, overruling Miller or Smith versus Maryland. And let me begin by identifying what I think are unique facts about this particular case. First, the summonses, the 26 summonses that were issued were suspicionless. They were not even based upon reasonable suspicion to suspect tax wrongdoing.
May I
they
ask you a
issued-
question about that, Mr. Fine? I saw that assertion being made repeatedly in the brief that the summonses were suspicionless, but I don't think I understood that. I was under the impression that the government had ample suspicion for the summonses based on information provided by Mr. Wittishek's, I guess, ex-wife, and based on problems with the information provided by Mr. Wittishek's then lawyer. So I'm a little puzzled as to why, and some investigation they had done into those. I'm a little puzzled why you say the summonses were suspicionless.
Well, one, they were issued pursuant to a provision in the law that provides an issuance of summons if it's thought that maybe something would turn up. There is nothing in a document like a warrant that sets forth the evidence that suggests anything more than, a hunch, a Mr. Macabre hunch, hoping something would turn up. And there's nothing in the
Well,
record. Your Honor.
if that's the argument, you're saying, in effect, I guess, that any summons issued in any tax investigation is suspicionless in that sense, because
It's possible. I think that it may well be in summonses. Most of the case here, the standard isn't even relevant. The standard under the provision is might be relevant to an investigation of a tax violation, and that is about as low as you can get. It's even lower than the standard in the former discovery rules. That you can get any discovery of a document that may be related to something that may be admissible evidence. And that's the reason why I put down suspicionless. And I don't think Your Honors can find anything in the record that can say, well, it raised to a certain level, whatever that level is, whether it's the stop and frisk level of reasonable suspicion or a probable cause. It's just what they may subjectively have thought that they had suspicion. But certainly that's just in their head. It's not in the record. That's why I use the term.
Okay.
I'm not sure I follow. You mean, the circumstances that Judge Glickman referred to in his question are circumstances that are in the record. Is that true?
Well, I don't know where in the record is that true. I mean, if you look at the summons,
Well, I guess
summonses
I'm asking you whether
I don't
there was
find-
information in the record about your clients' responses or responses through lawyers and problems with them. Now, maybe, it seems like there is a fair bit of information. We're talking about the trial record. Are you saying that you think that, I get your point that they are legally suspicionless in the sense that the law does not require proof of suspicion to a neutral officer before they are issued. So I get the point that they're legally suspicionless.
Mhm.
But if your argument instead is, actually, there wasn't any real basis in this case. Leave aside, nobody had to decide that at the time of the issuance of suspicion of the summons. I get that. But if your point is, in truth, when they were issued, there wasn't any real grounds. It was just a completely unwarranted fishing expedition at the time. I don't know whether that was your point in the trial court or whether that's your point now. But if that is your point, are you really saying there's nothing in the trial record that supports a conclusion that there were reasons to suspect your client at the time of the issuance of the
No,
warrant?
Your Honor, that's a wonderful question. I think if you look at the summonses themselves, it's just like summonses, take as an analogy to a search warrant. If you're looking at a search warrant, you look at the affidavit and determine whether there's probable cause under all the circumstances, the Illinois v. Gates. Now, maybe if there are things that aren't in the affidavit that establish probable cause but were in the record, the search warrant would still be faulty because it's got to be based upon the affidavit. If you look upon the summonses in these cases, the summonses just say, we're investigating Mr. Witteshek and we'd like you to give all this information that it's described in the summons. But the summonses are the legally relevant document here. And they do not refer to any allegations made by the ex-wife or anyone else under the sun. And it's that.
So I understand. I think we're just trying to clarify whether your point is part about what your point is and part about what the record shows. And
yeah,
if your point is only the law did not require that suspicion be established at the time of the warrant, the issuance of the summonses, and the summonses don't reflect the grounds for any kind of suspicion, then I think you're right. And the issue is, what does that mean legally? We were just trying to clarify, or at least I was interested in whether you could make an additional argument, which is, look, that's true, but this case is even worse than that. In fact, these were factually unjustified. It's not only that the warrant, the summonses didn't show any ground for suspicion, they didn't actually exist. And that makes it worse from a Fourth Amendment perspective. That is an argument you could be making. And I was trying to figure out whether you were making it or have made it. And if so, whether it's a good argument. And I get the sense that that's not really so much your point. And your point is more the legal argument.
No, I don't want to interrupt your Honor. I think your question is a wonderfully acute one. And one of the reasons why I think this particular case is problematic is because the standard might be relevant. That is, when they issued the summonses, they didn't even have to have any suspicion at all. They said, well, maybe something will turn up. Remember the pumpkin papers in Whitaker Chambers? That's the standard they were operating under. And they didn't put anything in the actual summonses that raised that standard to something more. Anyway, if that's sufficient, but I understand your point. I think, again, what seems to me unique about this case, this was an individual, not a corporation being investigated. It was criminal, was never contemplated at all. It would be civil. It extended over 7 years, not the 127 and 2 days of cell site location information that were at issue in Carpenter. It yielded 4,000 pages of documents that mostly were irrelevant. 95% the record shows, and the government hasn't disputed that. And of those documents that were disclosed, it painted a very clear, detailed mosaic of Mr. Witteshek's life. Again, these are things established in the record. The government submitted nothing to dispute Mr. Witteshek's affidavit describing how it disclosed his dating patterns, where he went to gyms, where his children were enrolled in schools, where he made charitable donations, his religious affiliations, his political affiliations, and things of that sort. And we're not saying that those areas are off bounds. If you get a search warrant, of course you can go there. We're not suggesting taxpayers are immune from investigation, especially
if this had been a civil action instead of a criminal investigation.
Yeah.
I'm not familiar with the tax procedures, but I am guessing from what I know of civil actions generally and the kinds of discovery they can generate, that the government could have done exactly the same thing and you would not have a Fourth Amendment claim.
That is absolutely correctly. And we're not disputing the same circumstances in a civil context can lead to a decision that's contrary to what would happen in a criminal context. That was a point I think that the U.S. Court of Appeals for the Seventh Circuit made in the Nashville case we discussed very briefly with regard to collecting information about water usage and metered. And that was a civil exercise like administrative summonses when you're, for civil purposes, perhaps searching houses for zoning violations and things of that sort. But this was a criminal case from the outset. And
well, what is your response to the government's good faith reliance argument? Because these subpoenas were issued well before Carpenter was decided, and there's a statute involved here. And in Carpenter, the Supreme Court said that the overwhelming majority of subpoenas would be just fine.
Yeah.
So what's your response? I'm not sure that I saw one or that you
Okay, well-
anticipated that in your brief.
Mhm. Well, I think if you look at the government relies upon the idea that, and we wouldn't dispute, and the court has held, where a statute on its face is held unconstitutional, we can't hold a policeman to adjudicating the constitutionality, the facial unconstitutionality of a provision. And there was good faith was then a defense to a suppression motion. But here, we're not arguing the summons provision on its face is unconstitutional. You issue a summons, you get a few bank records that are not sufficient to disclose someone's entire mosaic of their life. That's not going to be an unreasonable invasion of privacy, and that passes muster. But if you look at Carpenter itself, remember.
Before you go back to Carpenter, let me just make sure I understand. You're distinguishing Kroll on the ground that you think that the good faith, the exception to the good faith exception it is creating there, if I understand your argument, works if the police look at a statute and say, oh, the statute allows me to do something, and they do it. And then a court later says that statute is facially invalid, it's a complete nullity. Kroll says, as long as the police reasonably relied on the statute, we're not going to suppress evidence. And you're saying, okay, that works when the challenge is to the facial invalidity of the statute, but it does not work when the challenge instead is that the police look, and the statute seems to say that they can do what they can do. And a particular defendant says, well, yeah, we're not saying the statute is always unconstitutional, but there's a point where it becomes unconstitutional. And this is beyond that point. And therefore, the particular conduct here is an unconstitutional application of the statute. I don't understand why Kroll wouldn't apply there. It seems like that's a less fundamental defect in the statute that the police are relying on. It's a pretty good statute. Just maybe, it seems to authorize some things that at their extremes go beyond the fourth, at some point go beyond the Fourth Amendment. So I would think that Kroll is more a fortiori than distinguishable on the ground that you're describing. So could you say a little bit more about why you think that difference should bear on how the good faith exception to the exclusionary rule should work?
Yes, Your Honor. A wonderful question again. I think that if you take the position that any statute that authorizes an activity by investigators as automatic provides a good faith exception, I think that's the death knell of the exclusionary rule.
But I don't see, the word automatic in your answer seems a bit overstated. For sure, if the police rely on a statute that isn't facially invalid and they do something and their reliance is unreasonable, it's true a statute said it, but any competent law enforcement officer should know that's just not a constitutional application of that statute. Then Kroll will say that evidence will be suppressed. So it's not automatic. The issue is if the police reasonably rely on a statute and somebody later argues, well, in light of intervening case law, that application of the statute is a violation of the Fourth Amendment. I don't see why there's nothing automatic about it. It's just a question of, even in that setting, Kroll, I think, would tell you, you need to figure out whether the police's reliance on the statute to do what it did here in a particular case was reasonable or unreasonable. And when you were making that determination, you probably would look to pre-Carpenter law. But you seem to be saying a different kind of automatic thing, which is if the later challenge to the action that was taken under the statute is as applied rather than facial, then Kroll automatically doesn't apply and suppression automatically follows. And that, I guess, is where I'm still not quite following the chain of reasoning.
Well, let's take, Your Honor, the Carpenter case itself. The government relied upon the Storage Communications Act. And of course, Carpenter broke new ground. That's why we're here today. The court didn't say, well, we don't even need to decide whether there was a Fourth Amendment violation. This was a suppression motion, and the government reasonably relied upon the Storage Communications Act. You lose. But the court didn't do that. The court said, no, as applied to cell site location information, the government doesn't get away with access without a proper warrant supported by probable cause and issued by a neutral magistrate.
You can correct me if I'm wrong, but I just thought Carpenter didn't address a good faith issue. But a lot of courts have post-Carpenter. And they have looked at police action that was taken based on either case law or statutes that existed before Carpenter was decided. And there's quite a body of case law applying the good faith exception in that setting. And you think those cases are all I guess, fundamentally incorrect.
Well,
Because they, again, are missing this distinction about as applied or factual challenges to statutes?
Well, I think that, first of all, we would argue that it was unreasonable for them to think that as applied, this would satisfy the Fourth Amendment, because although there's nothing in particular record, I would suggest there's no other OTR criminal investigation of an individual covering 7 years that involved this massive amount of documentation, 4,000 pages, 95% irrelevant, but that created a clear mosaic of the defendant's life. But putting that aside, there's a doctrine, as you well know, in the US Supreme Court. They try to avoid addressing constitutional questions if they don't have to. And they've done that oftentimes, you know, in the good faith defense in Section 1983 actions under Title 42. If the court really believed that the good faith exception was going to quash any motion to suppress, why would they go out of the way to decide the Fourth Amendment issue and then say, but it really doesn't make any difference? It would be basically an advisory opinion. Now,
Not following, I guess I have to say I'm not following that for a couple reasons. First, obviously, the court is also a function of, going to decide the issues that are presented to it. And isn't the good faith exception is itself a constitutional issue? So I don't see that the doctrine of constitutional avoidance would tell you whether to pick a merits Fourth Amendment determination or a good faith exclusionary rule. Other doctrines of, ruling more broadly or more narrowly might or might not. But I'm not sure I understand your point. Are you saying that was a good faith issue presented to the court but not decided in Carpenter, or was the issue just not presented?
No, I don't think the court didn't alert to the good faith issue one way or the other in Carpenter. They're silent. Anyway, that's what I would extract from it. And Your Honor, this case, is one that was pending at the time. Carpenter comes down, and Carpenter should apply. New law applies to pending cases. And aside from that, we think that given the unique, extreme circumstances of this case, the fact that it's civil, individual, suspicionless, 4,000 pages, detailed mosaic of someone's life, spanning 7 years, and Carpenter was 127 days of cell site location information, or 2 days. You put all of that together in never considering a civil resolution of the case involving a tax issue of $55,000. That was not something, that's not a reasonable judgment to make. That vast scope of intrusion on Mr. Witteshek's life was justified under the Fourth Amendment without any probable cause, reasonable suspicion whatsoever.
Can I ask you, I want to give you a chance to respond to a procedural point your opponent makes. With respect to the good faith exception, your opponent says that was an alternative ground for the trial court's denial of the motion to suppress, that in your opening brief, you don't address it at all, and that therefore the issue is not properly preserved by you. And to the extent there is a pretty brief discussion of it in the reply brief, it's just not adequately briefed, and we don't even need to decide it. We could just say the following. The trial court denied the motion to suppress in part on good faith exception grounds. That was an independent, adequate basis for the trial court's ruling. That was not contested by appellant in the opening brief. We don't generally let people raise issues for the first time in reply briefs. The end, motion to suppress, affirm. Denial, motion to suppress, affirm. Do you have a response to that procedural point?
No, Your Honor. I'll accept responsibility. I think it's plain error here based upon the facts and circumstances of the case, and it's caused no prejudice to the government. Now, did you want to follow up further? I'd like to go now to the standard that's to be applied in Fourth Amendment suppression after Carpenter. It seems to me that the government takes the position that other than cell site location information, the third party doctrine is undisturbed. But I think that flouts the rationale of Carpenter. It wasn't just the fact that it was location information. It was the fact that the information that was disclosed by the documents painted a mosaic of the defendant's life. And the court cited with approval the concurrence of Justice Sotomayor in the Jones case. And I think the rationale of Carpenter means that the court below applied an erroneous legal standard to the Fourth Amendment issue, namely, third-party doctrine forecloses any win by Mr. Witteshek automatically because it's not cell site location information. We think that under Carpenter, as properly applied under its rationale, the test under the Fourth Amendment is reasonableness based upon all the circumstances in which.
But that's so abstract as to be indisputably true. And the Fourth Amendment says unreasonable search and seizure is not allowed. So yes, you're right. But can you provide? I know you think that it's wrong to read Carpenter as kind of a cell site tower location holding only, and the third-party doctrine remains, in full force in any other setting. I get that. But what is it? What do you think as a lower court? What is our standard? When, in what circumstances, what legal tests should we apply to determine whether police securing of information from third parties is sufficiently invasive of privacy as to require probable cause and a warrant? What's your test?
Okay, well, I understand, and the totality of circumstances test is not unusual in Fourth Amendment context. It's used to decide whether there's consent to a search, or under Illinois and Gates, whether there's probable cause. I don't think, unfortunately, that there is a bright line, but let me try to give my belief by this example. Suppose someone took a photograph of your index finger. It's anonymous, showed it to third parties. I think that that display would not be an unreasonable invasion of your privacy. An index finger, it's anonymous, it's not embarrassing. But suppose instead someone took a photograph of you entirely unclothed and disclosed it, and there's facial recognition out there and they know who you are. That's in a different universe of privacy invasion. It is, under the reasoning of Carpenter, a standard. It's not as definitive as perhaps Euclidean geometry, but a mosaic of someone's life.
Okay, so here's my hypothetical, just to explore why I think the Carpenter issue is so difficult if you, as a lower court, trying to figure out where the lines might be. So let's say that instead of issuing the summons, what the OAG had done, which would have been obviously infeasible, ridiculously resource impossible, they decided to go and interview as many people as they could find who know your client and get statements from them about everything they could find. They talked to his mother, they talked to his siblings about his childhood. They talked to his ex-wife about everything that, leave aside for a minute questions of marital privilege, I guess. But, and they talked, and so they paint through just interviewing witnesses. Like, they again, it's not, but only based on oral statements from witnesses. They have an unbelievable mosaic of your client's life. Does there come a point where their efforts at interviewing witnesses are so invasive of privacy that because they paint a mosaic of your client's dating preferences, where he is at any given time, where his kids go to school, what his childhood was like? Is it all just whatever the means? There comes a point where you just have learned too much and you need to get a warrant to talk to interview live witnesses, or I don't quite understand how it works. So what do you think? Is it really just a total quantum of information test, or do the means matter? And if so, how do they matter?
Well, I think, Your Honor, the means do matter. If somebody walks in and discloses a whole host of information on their own, no, you don't have a privacy right there. The government isn't even implicated. That goes
Sure, voluntary surrender of information by the target is an easy example of means mattering a little bit. But what do you say about interviews?
No, if the interview is voluntary, that's one thing. Subpoenaing someone just for the sake of subpoenaing without any further suspicions, then that becomes, perhaps a different matter.
Just to make sure, so if all of the records had been gotten here not by summons, but by going to, OAG going to each of these entities and saying, I wonder whether you're willing to voluntarily surrender. We're investigating this person. We wonder whether you're willing to voluntarily surrender some of your records. Would you say that's not a Fourth Amendment search, and it's the compulsion component of it to the third party that makes it a search, or is it that it's documents, or what is it?
Well, it's similar to the doctrine of consent search in Fourth Amendment, where the actual target says, okay, you can come into my home. Okay, at that point, you don't have any right to claim, well, you found things that I didn't want you to find.
You keep wrapping around to the easiest example, which is voluntary surrender by the target.
No,
himself.
but voluntary
What
surrender
about-
by third parties, about voluntary surrender by third parties. I think there's a case, I believe, Burrow versus McDowell in the 1920s, where the court held even information that's obtained people who obtained information by burglary who handed over to the government, that you can't describe government wrongdoing to the fact that third parties in the private sector did something wrong.
So you're saying that if the Carpenter comes out differently, if instead of trying to subpoena records from cell site tower location folks, the government asks, and again, leave aside for a minute whether the statutes permit this. They probably don't, but maybe they could. The government just asks, and the cell site provider said, yeah, we like to help the government. So anytime the government asks us, we're going to tell the government where our clients were. Based on our electronic records, you'd say Carpenter would come out differently, because what's critical is that the request to the third party is non-mandatory. It's mandatory for the third party.
That's correct. There's no government action. It's like First Amendment. You need state action, or civil rights cases, you need state action to implement.
Well, it's certainly action to go ask. It's certainly action to go ask somebody to give you information. That's action. It's not compulsory action, but it's action.
No,
It's
that's
not compelling a third party's action.
That's true enough, but if it's asking and the decision is made as voluntary, not over government coercion, I would not argue that that rises to the level of a government search or seizure within the constraints of the Fourth Amendment. And I believe in this case, although I'm not sure it's in the record, that the government did approach certain persons in Mr. Witashek's firm. They decided not to cooperate. The government didn't move forward and didn't get oral statements from them. But anyway, I'm not trying to suggest that that Carpenter, it makes it easy. The third party standard was rather simple to apply, but it's a reminder from H.L. Mencken that every complex question, there's a clear, simple, and wrong answer. It sacrificed privacy for simplicity. And I think Carpenter just found at certain points, it just goes too far. The third party doctrine, sharing information with the third party is an element, but it's not dispositive. Say it goes back to the difference between the Contreras case, which was one IP address. The government learned where the physical residence of the defendant was, but that was it. It didn't enable the government to have a complete mosaic of the defendant's life. That's not true in this case. The government has not disputed that the record established with Mr. Witashek's affidavit plus the summonses that a detailed mosaic of his life was painted. And that distinguishes this case from a whole host of others. Does it mean you have a bright line test? No, but unfortunately, the Fourth Amendment has few very, very sharp bright line tests. I think that lastly, Your Honors, the government argues that somehow a cell phone user doesn't know that when he uses his cell phone, that the cell phone provider has cell site location information that's collected and stored. And that's different because in this case, because Mr. Witashek should know that banks keep bank records and landlords keep rent records and things of that sort. But I don't think that distinction really is very persuasive. After all, if you don't want cell site location information gathered, you can throw away your cell phone. If you don't want bank records, kept on you, I guess you can not use a bank account. But we recognize today that's not plausible.
Yeah, Mr. Fine, I must tell you that it's that question of whether there's a reasonable expectation that society will accept of privacy on the part of the defendant. That I think is a point that distinguishes Carpenter from most of these other kinds of cases, including this one. In Carpenter, the Supreme Court was at some pains to say that merely by turning on your phone, information was going to be collected by these cell phone towers, and it would be just not correct. The Supreme Court simply could not agree that that was a case in which the holder of the cell phone, the owner of the cell phone, is in some sense voluntarily providing information and knowingly whatever the standard exactly is, to the third party. But that distinguishes cases such as this one, where Mr. Wittechek, for example, knows that all this information at his choice is being given to, or with his willingness, is being given to or collected by these third parties. And that implicates the general rule that what you voluntarily give to third parties and what third parties collect on their own and have information they have and develop, that is something in which you have no privacy interest that the Fourth Amendment requires respect for. Isn't that the distinguishing characteristic here? Even if it is true that by gathering up a lot of that information, as the government has done, they're able to create this notion of a mosaic of the person's life.
Well, I think that there's nothing in the record that suggests that a cell phone user doesn't know when he powers up and uses a cell phone that they're cell towers. That's how the cell system works.
We know that now, but the
that he
Supreme Court's
doesn't-
position in Carpenter was that people don't really know that it's not really a voluntary provision of information. I mean, there are problems with their position. You could say the same thing about Smith and the phone numbers up to the phone company. I get that. But this principle of where the expectation of privacy will be exists and will be respected seems to be a way of distinguishing Carpenter from this case, does it not?
Well, it seems to me, Your Honor, that it's a very thin reed. Suppose, for example, that the cell providers send out notices to the cell users saying, by the way, we collect cell site location information on you whenever you power up. Now, is the result different? Because now we know through the mail outs that the cell phone users know that it's being collected. I suppose they're public service advertisements from the Electronic Privacy Information Center saying you should remember as a cell phone user, they're collecting cell site location information on you. That seems to me rather
That point is a very fair
distinction
point,
to
and
make.
it could even go further and say, and by the way, if the government asks us for it, we'll give it to them. You could that's always been a problem with the Fourth Amendment analysis in this area. But I don't know how far that gets you.
Well, I'm just saying it seems to be an artificial distinction to make. Really, the Fourth Amendment depends upon whether the companies start or the electronic privacy centers alert people, especially young people who know this stuff at age 10 probably better than certainly I do. How these digital machines work. Yeah, they collect all sorts of things.
You may be right that it's an artificial distinction. The problem we have as a lower court is the Supreme Court seemed to put a lot of weight on it in Carpenter, so that makes it hard to know where to head with it. I don't want to prolong this any further, but I other than to ask at least one more question, which is I want to wrap back around to your answer to my question about other hypothetical cases and where you would draw lines. Because I asked you about what if the government paints a mosaic through witness interviews, and you said not a problem, no matter how detailed the mosaic, because if the witness interviews are voluntary, because that's just a different body of law. But I wonder, so what is your answer if the government instead had proceeded here in a hypothetical, let's say federal tax case, by way of grand jury subpoenas to witnesses to ask them for their live testimony about all the details, all the same details of your client's life. So the witnesses are compelled by government process to come in and testify under oath about it. But it's all just witness interviews. It's just painting a mosaic by asking a lot of people a lot of questions about what they know about your client, about where his kids go to school, and about where they've seen him on the street, and about who had dinner with him where, and if assuming again it's all at least legitimately directed to trying to find out where he was residing in the relevant time frame, but they paint the same amount of information, but it's all by grand jury subpoena. Do you say Carpenter tells you you need a warrant before you do that because it's mandatory and mosaic creating, or do you think maybe witness interviews are different even if compelled, or what's your response to that variant?
Well, I think the grand jury is the difference between that kind of subpoena and a summons. The grand jury is made up of citizens. They're supposed to be a bulwark, maybe not so much with prosecutors substantially control them.
Well, no, but
between
my
the
question is,
government
I understand there are lots of protections there, but my question is that a Fourth Amendment search? There's a question of what's reasonable under the Fourth Amendment, but my question is an antecedent one, not so much about what protections you get, but about, is it a Fourth Amendment search if the government, through compelled witness interviews, lawful compelled witness interviews, gets a very detailed mosaic of a suspect's life?
Yes, I think that is a search. It may be one that's a reasonable one that satisfies the Fourth Amendment. But I do think that it would constitute a government search. It's a compulsion and it's obtaining information.
And
Is
by the way,
it
it is a-
relevant to the issue of reasonableness that these subpoenas, as I understand it, were issued after your client's lawyer came in and spoke with the folks at OTR and attempted to show that he was a resident of New Hampshire during the period in question, sort of putting the issue of where he spent his time and lived and the like in issue? How's OTR supposed to respond to and analyze a claim such as that without obtaining information about where he spent his time and location? I mean, I think I disagree with you somewhat about whether the picture created was the same kind of comprehensive mosaic involved in Carpenter. This is not sort of 24/7, where was he? And OTR was stuck with trying to piece together things from debit card transactions, for example. We'll count him as being in New Hampshire on these dates because there was a debit card transaction, but really those transactions don't tell us anything about where he was at any particular location throughout the day. But to get back to my question, why is it relevant to reasonableness that your client had put this in issue with respect to where he resided, where he was domiciled, and where he was obligated to pay taxes? Why is this an unreasonable response when that's the issue?
There were not subpoenas, Your Honor. In this case, they were summonses.
I'm sorry, summonses is what I meant
And
to
so
say.
I would go back, Your Honor, in response. It's similar to how you evaluate the constitutionality of a search warrant that has to satisfy a probable cause standard. You look at the supporting affidavit. Now, if there was this evidence that generated suspicion that he was living in DC, not in New Hampshire, it should have been put in, or at least should have been provided or stated why there was this suspicion. It can't just be, well, it was in our head, we never communicated to any third party to review. That's one of the things that Justice Jackson emphasized in the Johnson case we cited upon. The important thing about the Fourth Amendment is not to try to shield a crime from investigation, but that the intrusion on privacy should have the shield of a neutral magistrate that makes that assessment. If the assessment was there, they could easily have gone if they had credible evidence and obtained a search warrant for these documents. They didn't do that. They just relied upon the summons, which doesn't have any standard at all. We're not claiming that maybe they could have satisfied.
Well, I understand that obviously they did not get a search warrant, but that did not seem to be your point. Maybe one of your points is that they didn't, but your larger point seemed to be that this was just unreasonable. If they had sought a search warrant, it shouldn't have been granted.
No, not necessarily. Well, obviously we'd need to see, Your Honor, what was in the affidavit. That would what we'd have to assess. The information in the affidavit, there's nothing in the record that enables us to assess anything here because the summonses themselves did not provide any level of evidentiary support. This is what's going to show 1, 2, 3, 4, 5. And I think it really does make a difference under the Fourth Amendment with regard to reasonableness as to whether or not you actually are able to convince a neutral magistrate that probable cause threshold has been satisfied, as opposed to just having the government itself decide its own level of suspicion and saying, yep, we passed muster and we're going to go forward.
Could I just ask a point of clarification? I'm wondering, when the summons is issued to all the various recipients, was Mr. Witteshek on notice of them? Or did he learn of them from the recipients? Or Can you enlighten me about anything on that score?
I'll defer to my co-counsel. My understanding is that the summonses were not routinely shared with Mr. Wittishek simultaneously with their issuance, but I don't want to speak, not knowing precisely. And my co-counsel, perhaps on his rebuttal, can give you the answer.
Okay. Or Mr. Martirana may know the answer to that too. Well, I think we've this has been an interesting argument. We've given you a substantial amount of time at the podium. You and your co-counsel will have a brief period for rebuttal. Let us hear from counsel for the government.
Good morning, Your Honors, and may it please the court. John Martirana on behalf of the District of Columbia. Mr. Wittishek is not entitled to relief on his Fourth Amendment claim or on his mens rea claim. With regards to the Fourth Amendment claim, there are three separate, independent, sufficient bases for this court to affirm the trial court's ruling. First, in accordance with long-standing, well-established Supreme Court precedent recently affirmed in 2018, there was no search here. Second, even if there was a search here, the good faith exception would apply because Mr. Agent Hessler relied in good faith on a statute and binding precedent in Miller at the time he issues the summons in 2014 and 15. Third, as Judge McLeese noted and counsel for appellant conceded, he's waived or forfeited on appeal by failing to address in his opening brief the good faith exception, which was an alternative ruling by the court. And then finally, with respect to the willfulness issue, the trial court correctly applied the mens rea standard, quoted Cheek, when it found that Mr. Wittishek knew exactly what he was doing was wrong, knew exactly what he was doing when he wrongfully claimed part-time residency and thus shielding his income from DC taxation. And I'd be happy to address each one of these arguments in turn, starting with the Fourth Amendment, there was no search. In Miller, the Supreme Court announced the third-party doctrine, and they recently reaffirmed that in Carpenter and said, we're not going to disturb the application of Miller and Smith to the types of records. And the Supreme Court basically said that they were going to address exceptions to the third-party doctrine on a case-by-case basis.
Why do you say types of, well, I guess it depends what you mean by types of records. Do you mean that you think no matter what, whatever the circumstances are relating to bank records are just a type of record that was covered by Miller, and Carpenter doesn't displace that. And so it's just impossible to, and same with like automated phone records, it's just impossible to surmount some sort of flat third-party doctrine rule, even post Carpenter. Is that your point, that it's kind of, what is the nature of the records? Are they called bank records? Are they called phone records? Or
understood, Your Honor. The records at issue are records either that were provided to a third party by Mr. Wittishek or belong to the third party themselves. And so that differs from what Judge McLeese said, or Judge Glickman said, beyond, the cell site location information in Carpenter was the whole of somebody's movements that's not really shared with them beyond that of powering up the phone. So
just to be clear, I take this as seems obvious, but I assume you'll agree with me that imagine that there's some new bank credit card that allows you, to sort of automatically, you can just like push a button on the card. It's got a little button and it'll communicate, electronically to the nearest ATM, and you can, send money off to people or do various banking transactions just with your card wherever you are. And imagine that banks end up having records as a result of that. that are, they kind of would always know where you are because your credit card now tells them that. You would agree that Carpenter might well govern, even though those are records that are held by a bank, or do you think actually it's just, if it's a bank, all bets are off, you're under the, Miller, and it doesn't matter really how invasive or how automatic or how high tech the information is. If it's generated by a bank, it's governed by Miller, and Carpenter can tell us nothing new about it. Is that your position, or do you think, no, it could be a bank record, but if it gets too invasive, too high tech, too automatic, it could be governed by Carpenter rather than by some flat rule or that you might derive from Miller or Smith or their combination?
No, bank records are covered because nobody expects, nobody has a legitimate, reasonable expectation of privacy in bank records. I mean, you know that when you swipe the credit card, you're not just sharing that information with the bank, but you're also sharing it with the merchant. And similar to what you said to my colleague, he can basically go to all the merchants and ask them, hey, did you see Mr. Witashek? What did he buy? When was he here?
Well, just to be clear about my hypothetical, imagine that in this future world where credit cards are, more like cell phones in some way, the bank records are now just like the cell phone company's records. The bank knows where we are at all times. Those are what the bank records tell the bank now.
My answer to the question is the same, Your Honor. These records were addressed in Carpenter, in Miller, and were reaffirmed in Carpenter. They said,
although in Carpenter, didn't the court say when talking about Miller and Smith, let's look at those records. They didn't really reveal a ton. That was a part of the analysis of why Carpenter was different from Miller and Smith. And so it seems at least potentially open to lower courts post Carpenter to be having, an inquiry that's a little more than Carpenter is a different rule for cell site tower location. Everything else is governed by a flat rule that is Miller and Smith, which is third-party documents. They're just not searches when the government goes and gets them from third parties. They're not searches of the person whose records, about whom information might be revealed by those third-party records. So I guess I'm just not quite sure if the court meant in Carpenter to say bank records are just fundamentally different. Why do they have the discussion and phone records are just fundamentally different? That kind of phone records, landline phone records, they're just fundamentally different categorically. Why is there a discussion in Carpenter that is in the nature of, well, let's look and see what the actual kinds of information at issue in Miller and Smith were. What's at issue in Carpenter is just way more intrusive, so it calls for a different rule.
That's correct, Your Honor. It is way more intrusive. And I do want to point out that, Chief Justice Roberts said that this was a narrow decision. We do not disturb the application of Smith and Miller, and the government is going to be able to get summonses and information through summonses in the majority of investigations. What I think you're talking about, Your Honor, is really whether or not there's a reasonable expectation of privacy. And there really isn't when somebody, shares records with a third party or uses a credit card and there's a statement that shows these different types of transactions that may, and the court even said in Carpenter that we're not going to address records that might tangentially reveal location information, and they said we're going to do it on a case-by-case basis. So in some of these cases with the emerging technology, there may be difficulty drawing some lines with the hypothetical, but the hypothetical drawing the lines, the lines have already been drawn here by Miller, Smith, Couch versus the United States for bank records, payroll records, records of sale. Donovan versus Lone Steer was a 1984 Supreme Court case talking about statement of sales and payroll records. All of these things, 1099s, W-2s, information about a taxpayer, from the taxpayer's employer. Those are all covered by the third-party doctrine, for which nobody can reasonably assert a legitimate.
You know what's funny about this in a way? If we're not focusing on this question of reasonable expectations of privacy, what the reasonable person expects, and we're focusing instead on the intrusiveness, it strikes me that if you said to me, all right, Glickman, we're going to have a camera following you in the sky, watching wherever you go for 10 days. Or we're going to get our hands on every record that exists in this 10-day period, showing what you purchased, where you traveled to, where your children went to. Which do you think would be more, et cetera, et cetera? Which do you think would be more intrusive? I mean, locational data, and I think the Supreme Court itself admitted this, only tells you so much. It may tell you that you went inside a building, but it doesn't tell the court what you did inside that building. But these bank records and credit card records and receipts and all sorts of other documentation, things you fill out when you apply for things, for when you get your children in school, when you go to court, whatever, tell a lot more about your life and are a lot more intrusive if they're all gathered together than mere locational data. Or if you don't want to agree with that, they're at least comparable to locational data. Do you disagree with that? And if you don't disagree with that, do you agree with appellant's claim that the records in this case did in fact produce a very intrusive, very detailed mosaic of Mr. Witashek's life?
I disagree that, well, to answer Your Honor's question about the location data for 10 days with a camera above.
Don't hold me to the precise specifics of my hypothetical. I was
right. Okay, Your Honor. I think that's a little bit different than the bank records at issue here, because it's really what the Supreme Court said was what they were really concerned about was the whole of the person's movements, and they relied on Jones and Jones versus the United States, where they used a GPS tracking device to track the car.
But the reason they're concerned about the person's movements is not because they're simply interested in traffic patterns. It's because they're interested in what those movements reveal about the person's activities and life. Compare Smith with, compare Smith with Carpenter. In Carpenter, we get all sorts of locational data, but we don't know anything about who the person is calling or seeing or what have you, not directly. With a pen register, the police learn the identities of the psychiatrist, the doctor, the girlfriend, the whatever, that the person is calling. And again, you could ask, well, which is more intrusive? That didn't seem to bother the court. The distinction that the court drew was not so much on the intrusiveness, I don't think, as on the putative knowledge of the defendant about what information is being collected by a third party and, voluntarily so. That's how I look at this. Isn't that, do you disagree with that?
I don't disagree with the way you've characterized Carpenter. I think that the court was very concerned about people's location and not truly sharing it with the third party. But again, the bank records here, the Supreme Court has already drawn the line, and that's they said we're only going to address this on a case-by-case basis. Miller and Smith are still good law, and we're still going to be able to get a majority of third-party records in government investigations.
Well, here we have a case-by-case basis. Here we have a case. Is it your position that no matter how many and what kind and over what period of time bank records, no bank records case can ever trigger the application of Carpenter?
No, no bank records trigger the application of Carpenter. Again, the Supreme Court has drawn the line.
Here we have more bank.
Yeah, it just seems puzzling to say, you keep saying the Supreme Court drew a line, but what they did sounded not like a line. They said, we have these earlier cases about third-party records. You know, that's not going to be, you know, Carpenter makes clear that that's not a flat rule, insensitive to circumstance. And they say, well, you know, we're going to proceed on a case-by-case basis, which seems antithetical to having drawn a clear line. And then they say, well, we have these two prior dots on the map, and we're not disturbing them, but they're pretty different. And they say things about them, about how intrusive they are, among other things. And then they do say, they give you some help about kind of where the line will be, or, you know, the pattern of decisions by saying, well, you know, this is a narrow decision, and we figure a lot of people will be able to, government will often be able to get information by subpoenas or whatever, you know, warrants or however they worded that. So they give you some kind of information about how to handle cases, and they tell you they're not disturbing two prior cases as they came out, given their somewhat detailed circumstances. That doesn't sound like a categorical line about bank records or anything else, really.
I understand the court's concern, Judge McLeese, but again, it goes to whether somebody really has a reasonable expectation of privacy in records that they share with a third party, or records that are created by a third party. And look at the records here.
I mean, I get that argument, but again, if you were right, the opinion in Carpenter should have been written in the following way. We have a rule about bank records. You know, you can get them whenever you want without, it's not a search. But this isn't a bank records case. This is a case about, you know, cell site location. It's different from bank records, because bank records, everybody knows they're being generated. And this case isn't like that. I mean, if Carpenter were written that way, then you would have a really good case that Carpenter created a flat rule. But Carpenter isn't written that way. Carpenter more says we have said these third-party things, and you know, we're going to proceed on a case-by-case basis in this area, and where the government is using high tech to get lots of information, you know, is one example of where we're going to not just have a categorical rule about third-party doctrines, and we're not, you know, it's a narrow decision. We're not upsetting the outcomes of our earlier cases on their facts, which we're going to look at in detail. So Carpenter really is written in a way that seems to me to suggest the opposite of what you are arguing, which is that there is a categorical rule about bank records that was stated in Miller and was reaffirmed as a categorical rule about bank records in Carpenter. It just doesn't, I have a hard time reading the opinion that way.
Two responses to your question, Your Honor. The first is that, you know, everybody knows that when you enter a transaction with somebody, that they are going to generate a record, like a bank or like a lease or W-2 forms. There's going to be a record generated as a result. And people don't have a reasonable expectation of privacy in those particular records. Second, like you addressed with my colleague, you know, and I see my time has expired. May I finish the question?
Yes, please do.
Okay. Like you said with my colleague, you know, the agent could have just gone to the merchants themselves or to the schools themselves and said, hey, you know, have you seen this person? And this is Mark Witashek. You know, does he purchase things here? When does he purchase things here? You know, what day, what time? And that would not be a search. That would just be an investigatory avenue. And that's not a search. That doesn't implicate the Fourth Amendment. And the reason is because the person that you really don't have a legitimate expectation of privacy, you know, in records that you share or records that are created by a third party. So moving to the good faith exception,
Before you do that, Mr. Martirano, let me just ask you this question. Your opponents say that the summonses were suspicionless, and Mr. Fine emphasizes that they covered 7 years. First of all, is that factually correct? And what does the record tell us about why 7 years or 5 years or whatever it was worth of data was sought?
Yes, Your Honor. There were 7 years of data sought because there were 7 years of tax return information where the statute of limitations had not expired on those tax returns at the times the summons were issued. With respect to looking at each one of these, I don't think my opponent can say that you have to consider all 26 summonses in the aggregate. I think you look at them one by one, like they did like the Supreme Court did in Oklahoma Press Publishing Company versus Walling. They took the summonses one by one. And then third, the way this actually progressed was that Mr. Witteshek, the information was provided to OTR by Mr. Witteshek's wife, and bank records were given to OTR by Mr. Witteshek's wife. And the agent pulled the tax returns and saw that there was a discrepancy. They called Mr. Witteshek to try to resolve the matter, and Mr. Witteshek sent an attorney with what is in the record as Government's Exhibit 5 that purported to justify why he took the part-time residency deduction, and that the summonses then thereafter were issued, to confirm or dispel, Mr. Witteshek's claims himself. So I agree with you, Judge Thompson, that he did put this at issue. This wasn't just, a fishing expedition off the bat. I mean, all of these summonses were relevant and material, like the statute requires, to the ascertainment of a tax liability. And so, really, the good faith. Going back to the good faith exception, if I may, Judge Thompson. If you look at what Carpenter did on remand, if you look at the Sixth Circuit case, it's at 926 F3D 313. It's the Sixth Circuit in 2019. They went ahead and they did not suppress the cell site location data. They said that the court in that case said the good faith exception applies here because when the government was relying on that statute and it was relying on it in good faith. And so, the same rings true here in Illinois v. Krull, that you don't suppress, you don't suppress information. You do that to deter poor law enforcement conduct. And, he didn't do anything wrong here because at the time he issued the summonses, Carpenter hadn't even been decided. I mean, the agent didn't have a crystal ball that he could look into and say, oh, well, this is going to get invalidated in 2018 by Carpenter. So the good faith exception really does apply here. And, as my opponent conceded, he didn't address the basis for the trial court's original ruling or the alternative ruling in his opening brief. So he's waived that or forfeited it on appeal. And could I address just the willfulness very quickly?
Yes.
Okay, so the willfulness claim here, I mean, here's a certified financial planner who's got a background in education in wealth planning and tax planning, and he moves from New Hampshire in 3 trucks and brings his family to Washington, D.C. He registers cars here. He gets a driver's license here. He sends his kids to public schools here. He titles his vehicles here. He enters one lease at 2806 University Terrace for 2 years. He then goes to 3114 Q Street, extends that lease through 2015, although he left in 2013. So at that time, all of this information showed that he actually knew that he was a resident of the District of Columbia. And the willfulness here is overwhelming. The evidence of willfulness is overwhelming. But addressing the standard, the court actually did apply the correct standard. Judge Soltes on pages 4, 5, 9, 16, and 27 of the November 5 transcript, quoted the Cheek decision, said a good faith belief will negate willfulness. And to go to Judge McLeese's earlier question to my colleague about is reasonableness irrelevant? I'd like to answer that question and say it is not irrelevant. The reasonableness of the belief can be used as a factor to determine whether somebody actually held the belief in good faith. And if you look at Hawkins, the court says it's got to be a good faith belief, but you can consider the unreasonableness on that of the belief. So for example, in the Hawkins case, there was a bike, in a bait bike operation that they left on the side of the road, and they waited for somebody to come and steal it. And when it came to trial, the defendant said, well, I thought the bike was abandoned. And you look at the reasonableness of that belief. Was it next to a trash can? Was it chipped? No, this bike was brand new and it was just sitting there. So when you're talking about the reasonableness of the belief, that does factor into whether somebody actually held the belief. And the court, applied the correct standard, and Mr. Witteshek simply cherry picks the word reasonable, 2 or 3 words of reasonableness out of the transcript. And he claims in his brief that he was held to a higher standard. And I just would invite the court's attention to United States versus Guidry, which is United States versus Smith is 890 F2D 711. It's a Fifth Circuit case where the court held that his business acumen, the taxpayer's business acumen as an entrepreneur, was relevant to the issue of willfulness. You can see United States versus Guidry, where a defendant's business degree and their accounting experience supported willfulness. And, here, the evidence was just overwhelming. I mean, he was asked and he repeatedly lied to the investigator. Instead of, he said, well, I lived at 1555 River Road. And then the investigator issued a summons and found out that it was his client's address. And he comes back, Mr. Witteshek comes back and says, well, no, it was 55 River Road. And then they go investigate 55 River Road. And there's no connection to that address. And just the icing on the cake is when he does find out that he's under investigation by OTR, he calls a hotel in New Hampshire and says, hey, I'm on full-on criminal investigation. I'm being audited. Can I pay a fee to use your hotel as my residency? So, the court clearly thought he was incredible. The evidence of willfulness was overwhelming. She applied the right standard, and the district would ask this court to affirm on the grounds, on the Fourth Amendment grounds previously cited, and on the willfulness being properly applied. Thank you.
Thank you. So, Mr. McEachin and Mr. Fine, we'll give you a few minutes in rebuttal. And since there's 2 of you and probably both of you want to speak, we're going to make it just a couple of minutes each, I think is fair. Mr. McEachin?
Yes, I'll go first. I'll be a little bit brief. With regard to what counsel just said, in citing the case, I think it was Guidry, if I'm not mistaken, but he did. I'm not sure if that was the eventual case, but the issue being the occupation of the person in relation to considering reasonableness, there has to be a nexus between the occupation and what's at issue. Simply being a professional doesn't make you learned in a certain issue. It is because in another issue. So when you look at this case, there has to be some nexus between what Mr. Witteshek's occupation is, what he learned in that occupation, which is actually in evidence and not speculative information, as to his ability to determine his part-year residency. With regard to what was being said about the Hilton and an address, Mr. Witteshek explained the issue with regard to the beginning of this investigation was April of 2014. Mr. Witteshek approached the Hilton in January of 2014. There was no way for him to even know anything about the investigation. It preceded the investigation. And what Mr. Witteshek explained was that he was considering moving back to New Hampshire, where he now lives and has lived for approximately 7 years, and was concerned about a special needs child and trying to get that child into an enrollment list in school. But the point is that it predates the investigation. So while it's a red herring, when you look at it, it really doesn't provide anything. And
So his defense at trial was that the employee of the hotel who reported a very different conversation was what? Lying, making it up, confused, thinking of somebody else? Where did
I'm sorry.
Where did that other conversation, what was the defense theory as to where that other conversation described by that person came from?
These were only notes that were written down by the person, which that was linked to be the time frame, but the person never indicated specifically that Mr. Witteshek didn't have a conversation with him in January concerning that issue. So, or concerning when I say the issue, not the issue of the special needs child, but the issue of the address. There were some notes made on there and some notes referring to April, and that was led to believe that was in fact when the conversation occurred. But the conversation occurred back in January for the reason that I've already addressed. So it was not the testimony of the person directly that I had this conversation with him in January. I had this conversation in March. It was that, April. There were notes affixed to some, as she wrote down things about it, and that's what led to the temporal issue.
So leaving aside the temporal issue, I
Yes.
take it you're not denying then that the conversation as reported by the hotel employee occurred?
No, I'm not denying that, but the reason for the conversation is the real issue. Because
Whatever
of the
the reason
reason
was, the question is what he said in it. And he said, maybe we're not communicating and I don't want to prolong this, but
yes,
regardless of what reason in his
Yes.
own mind he had for having that conversation, the hotel, if I understand correctly, the hotel employee reported a conversation in which he basically said, he didn't say anything about, I'm thinking of moving back here and I need a place for my child. He said, I've got this criminal investigation and I want to demonstrate that I have a residence here. Can I pay you a fee so that you'll say that you're my residence? Are you saying now? So I asked you to explain to me. Are you saying, what was your answer to that conversation? I can only think of a couple of answers. One is she's confusing him with somebody else. Seems unlikely. The other is that she's just plain lying because she has some malevolent motive. I don't know if there's any basis for that. Or third, you don't have any answer.
I'm sorry, I didn't completely understand the question. I'll be very succinct with it now. It is our contention that the conversation happened in January. Once the
I don't care when it happened.
well,
I want to know what your answer is as to whether that conversation was faithfully reported or not, the content of it. And if
no,
not,
I don't believe it was faithfully reported.
if not, what your explanation is for how the person could give that account.
My explanation.
What was the defense to that at trial? That's what I'm.
Yes, the explanation is that the conversation, as I said, happened at the time it happened back in January. But when asked about that, the witness indicated that there were some notes the witness had made concerning the communication, but those notes were made after the communication had occurred. By that time, there had been criminal investigators asking about Mr. Witteshek, which led to the belief that there was something with regard to his taxes. But Mr. Witteshek, but that's how in fact, how that all occurred. The timeline was January is the conversation, that the conversation that once they learn about the issue of the criminal investigation in April, there are some notes made regarding that, but the conversation actually occurred in January.
And when you say, in fact, that's how things happened, you mean that's what your client testified to, although this isn't your point, but the trial court didn't credit your client's testimony, at least in a variety of respects.
Well, yes. When I say in fact, that was our contention at trial. Yes.
Let us now hear a couple of minutes in rebuttal from Mr. Fine.
Yes, and thank you, Your Honor, and your judges for being so indulgent here. I'll try to be exceptionally succinct. One, I think my colleague is wrong in suggesting that the Fourth Amendment issue is addressed on an individual item by individual item basis, as opposed to looking at everything in collectivity to determine whether a mosaic of a life has been portrayed. Take Carpenter itself. Suppose instead of asking for 127 days of cell site location information with regard to one order, they just carved that up into 127 separate ones and said, well, 1 day of cell site location information isn't going to pone a mosaic, so let's just do it 127 times and we'll just look at it one by one, and then we'll escape Fourth Amendment scrutiny. I think you've got to look at the totality here, and it's the collectivity of this 26 that has to be examined to determine whether expectation of privacy was violated. And indeed, the government doesn't indicate that there's any limit on the number of summonses that could be issued. It could be hundreds, thousands, whatever. It's just limitless. It's automatically going to satisfy the Fourth Amendment.
May I ask you a question that occurred to me when Mr. Martirana, brought up the what happened to Carpenter on remand? I thought that was rather interesting, that even on remand from Carpenter, if I got this correctly, the Sixth Circuit held that the good faith exception applied. Isn't that a pretty powerful argument for saying that 4 years earlier, when the police arguably, the government arguably did something similar to Carpenter, the good faith exception should apply to that too?
Well, I think it is an argument. It's a Sixth Circuit decision. It's not a U.S. Supreme Court decision. But I think these kinds of issues of reliance come up regularly when the court decides, how retroactive a ruling ought to be. Take Miranda versus Arizona. Well, did the police really know that they had to give Miranda warnings until Miranda was decided? And yet the un-Miranda interrogation was suppressed as a violation. I don't think it's dispositive here. I think if you look at the totality of circumstances and the fact that even before Carpenter, the Jones was giving signals that the expectation of privacy has to be based upon social realities, not what happened 40 years ago. And social expectations have changed in the digital age. I'm sure that's with regard to yourselves and your law clerks and whatever. And that it's unreasonable to think that these 26 summonses, 4,000 pages, they had good faith belief that that doesn't run into serious Fourth Amendment issues. With regard to I was able to clarify one, no, Mr. Witteshek was not alerted of the summonses, and I believe the first ones were issued even before his attorney came in and spoke with the investigators. But I also think that if we're arguing about whether there was something more than just hunch to support the summonses, and the argument is, well, there's other evidence that came into the case, although they weren't inserted in the summonses, that provided more than just a roll of the dice. But the fact is, when we created the record for the motion to dismiss, and we put in the record Mr. Witteshek's affidavit and the summonses, the government didn't come back and say, well, they really weren't suspicionless. We really had something like probable cause, or at least reasonable suspicion. They didn't put that in the record in opposition to the motion to dismiss. And I come back, I think it's persuasive. It's the same way in which you examine the legality of a search warrant. You look at the affidavit, and if there's information that's in the possession of the police, they don't put it in the affidavit. The court doesn't enable them to supplement it, by speculating, well, what was in the police officer's mind, even though it wasn't shared with a neutral magistrate. I think the same goes here. They may well have had ability to go and get a search warrant, but they didn't. And there's a price for that. As Justice Jackson underscored in the Johnson case, there's a reason why the Fourth Amendment wants a neutral magistrate to draw inferences from information rather than those who are involved in the competitive process of searching out crime. It's likely to be less biased or less skewed. And that's one of the reasons why we have the Fourth Amendment at all. But anyway, that's the gist of what I wanted to clarify, Your Honors. And I really appreciate the time and attention you amassed to the record, and the questions were all wonderful.
Thank you very much, counsel. The case is now submitted, and we'll let you all log off.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
We're ready to call the third case on the calendar, Quentin Workman versus United States. Let's see, we are waiting for the government to log in. Mr. Brannon, can you please check?
Yes, Judge Lichtman, Ann Carroll is joining. Give her a few seconds joining.
Okay, thank you.
Sure, you're welcome, Your Honor.
Ms. Carroll, good morning. Mr.
Good morning, Your
Collins?
Honor. I'm here.
Good morning. If it is still morning, it's not.
It's not. Good afternoon, Your Honor.
Good afternoon, Your Honors.
Mr. Collins, you may proceed.
Good afternoon,
I don't
and
know if you heard, we've called the case. Go ahead.
Okay, I'm sorry. Good afternoon, and may it please the court. William Collins on behalf of the appellant, Mr. Quentin Workman. I'd like to request 2 minutes of my time for rebuttal.
That's fine.
And I'd like to start by focusing on 2 concessions that the government made in response to Mr. Workman's motion to dismiss with prejudice that entitle Mr. Workman to prevail in this court and entitle him to reversal of his conviction. The first of these concessions was legal, the other was factual. The legal concession was that Rule 48A2 applied in this case based on the government having declared itself no longer ready to proceed upon learning that the court had denied its motion to continue and excluded its DNA evidence. The factual concession was that the government had declared itself no longer ready to proceed for the specific purpose of circumventing the trial court's rulings in that regard. And
well, I don't think it's fair to say that the United States conceded that its purpose was circumventing anything. So that must be your gloss on what they actually factually conceded. Or did they, is there a concession about the United States using the word circumvent?
They don't use the word circumvent, Your Honor. What they say is we were attempting to address this circumstance, which had been determined to be a discovery violation, in a manner that would allow them to present the evidence at a future date after the continuance had been denied. And that would allow
why do you say that? I leave aside how the United States worded the factual concession that you're referring to. Why do you think it's fair to refer to it as a circumvention, whether the United States conceded it or not? One way of looking at it, assuming for a moment that we should view this as a case in which the United States moved for dismissal without prejudice. The trial court gave the United States dismissal without prejudice, and everybody knew why it was going to be a dismissal without prejudice, and everybody knew what was likely to happen thereafter, which would be that the case might well be reindicted, and at that reindicted case, the United States would try to get in the evidence that was, creating the current problems. And the trial court knew all of that. The trial court nonetheless granted, in your view, the government's motion to dismiss without prejudice. So why is doing what everybody understood would happen, a circumvention of the ruling that allowed it to happen. That's where I get puzzled.
Your Honor, we take issue with the characterization that it was known that the government would just come back into court with a new indictment and the same evidence. What the government said was that we are no longer ready to proceed because of the evidence being excluded. At that point, as we've mentioned in our opening brief and as the government concedes, it had the option to take an appeal, and that would not have constituted harassment in the same way that just coming back into court with the same evidence and the same exact in a new posture at a later date. That would
Why
not
would
have
the government,
constituted.
why would the government have wanted to take an appeal? The government agreed that the defense was entitled to more time to prepare its response to the DNA expert, and the government was happy or content with the dismissal without prejudice. And the defense counsel apparently was happy with that, because defense counsel never objected to the dismissal without prejudice, and never argued that the dismissal should be with prejudice. So I don't understand why you think the government should appeal. They're happy with what they got. And indeed, I don't understand why this whole issue wasn't waived or forfeited by the defense failure to object to the court's ruling dismissing without prejudice. But
So, Your Honor, I guess going in reverse chronological order of your questions, I don't think this issue was waived by defense counsels or by anything that happened on March 3rd. And I believe that the government has waived any argument that defense counsel waived.
that may be
Waive the argument that we currently press.
There might be a waiver of the waiver.
I'm sorry, Your Honor.
I agree with you. There might be a waiver of the waiver, as it were. But the government has objected on appeal that defense counsel didn't object and never asked for a dismissal with prejudice.
So, Your Honor has asked, why would the government take an appeal under the circumstances that were present on?
Yeah, they're happy
March
with what they
3rd?
got.
But it wasn't clear what they had gotten. And I think it's very important to read the record carefully of what happened when the case was dismissed. The government just said, we are no longer ready to proceed because of because of the evidence not being introduced and because of this property availability issue that the government has, we submit, withdrawn. It's not clear at that point what they were planning to do. Now, what defense counsel said.
I don't leave aside whether it's clear what they were planning to do. You said it's not clear what they got. And I want to zero in on that aspect, because if we're taking as a given, as you would like us to, that this occurred under Rule 48A2, and in substance, the government was moving for dismissal. That's a premise of your argument. Let's just accept it for the current purposes.
Yes, Your Honor.
Well, then it's clear what they got, isn't it? Because Rule 48A2 says that a dismissal is without prejudice unless it says otherwise, and it didn't say otherwise. So it's very clear what they got. And in fact, if you drill into what the parties are saying, the defense attorney is making the point that the government announcing not ready is really kind of frustrating your don't let them kind of stampede you into anything by announcing not ready. But then the defense attorney starts talking about like what will happen in the release of the client if the dismissal happens. And if the dismissal was going to be with prejudice, a lot of what the defense attorney was saying would be completely nonsensical. So it seems to me that whatever else you can say about what people understood or didn't understand, everybody did understand or should have understood, I think both, what was happening, which was a dismissal without prejudice. Because again, the premise of your argument is 48A2. 48A2 couldn't be clearer that unless the judge says prejudice, it's not prejudice. And the judge didn't say prejudice.
I apologize, Your Honor. And I want to clarify you've correctly stated the premise of our argument. What I'm saying right now is that it would not have been appropriate to bar the government from further prosecution at that date because it wasn't clear exactly what they were planning to do in light of their inability to use the evidence. They could have taken an appeal. They could have tried, the government has cited these cases in the District of DC where the government attempts to conduct further investigation. And I think that's
Can I understand, or again, I'm getting a little confused. If we're taking the premise of your argument that it was the government's motion to dismiss, you think the government could take an appeal from the motion to dismiss, the granting of its own motion to dismiss?
No, Your Honor, I think the government, so DC Code 23104 stipulates that the government is allowed to appeal the preclusion of evidence that has a substantial or is substantially relevant to the charge.
Oh, well, you're certainly right that rather than making what you claim was an implicit motion to, and what the government may well concede was an implicit motion to dismiss, the United States could have said, Your Honor, you are excluding evidence, and we want to take a pretrial appeal. So hold this matter in abeyance. We're noting an appeal. That's true. That was an option available to them. I agree with that point. I'm not sure where that leads you, but I agree at least with that point. I don't think they could have appealed. I'm not sure they could have appealed their own dismissal. That I'm more doubtful about.
I was not suggesting that, Your Honor. I was only suggesting that it was their option to take an appeal of the court's sanction under Rule 16. And
right, but then since the government forewent that option by instead you say implicitly moving to dismiss, that the possibility that the government might appeal was not something that would have been in the defense counsel's mind, explaining why defense counsel would have not asked the court to dismiss with prejudice. You raised that because you were saying there were reasons why defense counsel wouldn't have moved to dismiss with prejudice. But one of them wasn't, well, I don't know, maybe the government will appeal.
Sorry, Your Honor. I don't think that's necessarily true. I understand the court to be saying that the government could have just held the case in abeyance while it took the appeal. But we've seen in practice, they do dismiss cases while they seek a government appeal. So I don't know why trial counsel would have ruled out that possibility altogether. The other possibility, Your Honors, which the government.
But can I make sure I understand what you're saying? You're saying that you're aware of cases in which the trial court excludes evidence and the United States both takes an interlocutory appeal and during the pendency of the appeal dismisses the case and tries to pursue the appeal?
I'm aware of
its own motion?
I'm aware of one case in particular, Your Honor.
All right.
I mean, it's can
I ask you, that seems odd to me, but maybe that's happened. Can I ask you to make sure I understand another point you were making? You're somewhat, you made the further point, if I understand it, that essentially it would have been premature for the defense attorney to say, Your Honor, grant dismissal with prejudice, because the dismissal that you say the United States was asking for would have been a dismissal, and then we don't know what would have happened. It might have been that when the case geared back up, the United States would have foregone the evidence that it was relying on, in your view, the unavailability of which it was relying on to make the motion to dismiss. But and that just seems like it doesn't make any sense. If you're saying the United States said to the judge, essentially, you've just excluded some evidence. We're not ready to go today. We'd like you to dismiss this case without prejudice. Well, like the only possible thing they're going to do is then, later when the evidence, the defense will have had time to address the evidence, then, the evidence will come back in. There's no other thing that anybody could have had in mind about what was going to happen. That was, in your view, that's the reason they were asking for the continuance, is because they didn't have it now. Well, the dismissal. So how does dismissal help them unless they're going to use it later? There's no reason for it unless they're going to use it later. If they weren't going to use it later, they should have said, well, let's go to trial because we don't have any plans to use, you're telling us we can't use this evidence. We're not going to use it again. So let's go with what we have. Why dismiss and then start all over again and then not use the evidence that was the basis, in your view, for the motion to dismiss? I don't understand what anybody could have been thinking other than that the plan was for the government to try to use it after a reindictment, if reindictment occurred.
Your Honor, I would just point, Your Honor, to the cases cited by the government in their opposition, which refer to a changed circumstances doctrine under which they might seek to conduct further investigation when they lose the use of certain evidence. I think that would have led into an entirely different analysis and we'd be arguing about different things. But at the same time, I don't think under the record as it was presented, it's appropriate to say everyone knew for a fact what was going to happen. I also would submit that when defense counsel said, we believe that the government is trying to circumvent the court's ruling, and that's going to put us right where we would have been had a continuance been granted, which it was not, it was denied. At that moment, it's not as though the government said, hey, okay, you got us, that's what we're going to do. And it's also not the case that the trial court made a finding that I do believe this is what happened.
But that very statement indicates that counsel was well aware that what was going to happen was exactly what Judge McLeese has sort of articulated. Mr. Collins, may I ask you a question to clarify something for me that I realize now I'm not entirely clear on? When you say that the government, that there was also a legal concession by the government, that Rule 48A2 applied, what are you specifically pointing to for that proposition that the government legally conceded that? Or conceded that legal proposition?
Certainly, Your Honor. So we have page 6 of their opposition to the motion to dismiss, which is record document 31. And they say, as defense counsel concedes, the key factor in a determination of prosecutorial harassment is the propriety or impropriety of the government's efforts to terminate the prosecution, the good faith or lack of good faith of the government in moving to dismiss. The government must not be motivated by considerations clearly contrary to the public interest. Here, there simply has not been a showing of bad faith. We go further to page 6 of the hearing transcript on June 28th. The counsel for the government states, I think defense counsel is absolutely right that there's not a lot of case law here, but I think that the sort of bedrock principle is that really a good faith analysis. This is really a good faith analysis. And as I've tried to lay out in response, we really did at every step acknowledging that there were certain administrative difficulties, really try to make the defense and the court aware of what was going on and take those steps to remedy that situation.
Now, let me ask you a follow-up question about that. You may well be right. I'm just trying to clarify this in my own mind. If this had been a Rule 48B motion, would it still be a good faith? And I mean, would much of what the government was saying there and those two things you quoted also be true, that it's a good faith analysis and so on and so forth?
I think a Rule 48B analysis, no, Your Honor. So I think a Rule 48B analysis would take into account expansively the reasons for delay, because the whole bedrock principle is the cause of the delay, the unnecessary delay. You know, the whole issue is about the unnecessary delay. I would,
in many cases, right, but I wonder whether whether on the facts of this case, if the defense had moved, if everybody had agreed, for example, this is a defense motion under Rule 48B to dismiss with and we wanted with prejudice, you would think the inquiry would be the same. I mean, I guess I press this because I really think that, or I think there's a good argument that this was really a Rule 48B motion. But I'm not sure it makes that much difference, but that's what I'm trying to sort of get at.
I understand, Your Honor. And I would point Your Honor to a couple of things. One is that when the government is making these arguments, they are citing to and referring specifically to cases that are parsing the harassment analysis under Rule 48A. And I quoted, Your Honor, from their opposition where they're quoting Salinas, which is a case we had chiefly relied upon. There had never been a moment where they said, we are taken aback and this was the defense's motion and we don't understand why we're even being put in a position to respond to these kinds of inquiries. And it could not have been more clear that they were accepting the premise that Rule 48A is what applied and that they had in fact had occasioned this dismissal.
Can I ask you a question about, go ahead.
No, go ahead.
I was going to shift topics a little bit and just ask, do you think it would have been an abuse of discretion for the trial judge to have granted the government's motion for a continuance?
Actually, let me piggyback because I was going to ask about the same thing. My question was going to be, I'm just trying to understand the court's reasoning, though perhaps it doesn't bear directly on the issues. The court said something like, I might grant a continuance, but the defendant is being detained, so I won't. I kind of scratched my head over that. So I wonder if you understand the reasoning.
No, Your Honor, I don't. or I'm
I mean,
trying.
because he was being detained on something else as well, a parole detainer, or I think it was called.
Is Your Honor's question why she denied the continuance in light of the fact that he was being detained on?
Yes, when he was not being detained simply because of this case. That's my question. And I'm sorry if I made you forget Judge McLeese's question. I apologize.
Oh, so I thought Your Honor had been asking a different question, which was why it would make sense to, anyway, how to reconcile the two different rulings. But the court had before it a very ample record, which had been made by defense counsel regarding how, at the very least, neglectful and unreasonable it was to have not tested this evidence, done anything with this evidence for the entire life of the case up until the month before. And I had quoted from her ruling in our opening brief, and I could read, Your Honor, from it at this moment, but I certainly don't think it's a nonsensical or abusive, any kind of abuse of her discretion. Now, I think it's important to note, insofar as Your Honor might take issue with it, it was a discretionary ruling, but the government voluntarily forewent the opportunity to take an appeal of her reasons for granting this, or for refusing to grant this continuance. And so, these were the issues that prompted the court's sanction. And if, insofar as the government had any kind of, had a legitimate gripe with her continuance ruling and the imposition of the sanction, it behooved them to present those under DC Code 23104.
I agree with that aspect of your answer, but just to, again, to wrap around to the flip side of it, because there's a relationship between the two questions, and I just to finish the other half of it. Do you think? I mean, I understand the trial court didn't grant a continuance, and the United States is not well positioned to dispute whether that was a correct ruling or incorrect ruling. But my question is a little bit different and kind of hypothetical, which is, would it have been an abuse of discretion for the trial court to say, look, the government did not comply with Rule 16. It was belated, doesn't have good excuses. I'm excluding the evidence for now. There's no way we're going to trial today with that evidence. So, I'm not necessarily even excluding the evidence. What I'm going to do, though, is I'm going to grant a continuance and then, give the defense what time it needs to, prepare to meet the evidence. Would that have been an abuse of discretion in your view?
On the record here, yes, we think so.
And would it be a further abuse of, would it have been an abuse of discretion if the trial court had not only granted a continuance, but had also started addressing detention issues and had said, the United States didn't handle this well. I'm not going to let it go to trial today with this evidence. I want to make sure the defense has a chance to address it. I am going to grant a continuance, but the defendant is being held in this case. We're already over 100 days. Now, some of that is due to scheduling. And I know the defendant is being held in another matter, but I'm going to release the defendant in this case, which may mean that ultimately he'll be able to secure his release in connection with the parole detainer. And that's the way I'm going to strike the balance. I'm going to give the government more time and let the evidence come in. I'm going to give the defense time to address it. I'm going to make sure the defendant doesn't suffer any prejudice in this case because, or at least direct prejudice in this case relating to his detention status. Would that also, in your view, have been an abuse of discretion?
Again, I think, so yes.
That seems like a hard argument. I guess, what the trial court did, though, is somewhat more favorable to the defense than what I just described. Because it did all of that, and then it also required the government to go re-indict. And your view is essentially, I think, that doing that is also an abuse of discretion. That granting a dismissal without prejudice, contemplating that the government would do that, was an abuse of discretion. I think in some ways your argument might logically boil down to that proposition. Do you agree with that or disagree with that? That you think your argument is, let me ask you this. Assume that I thought that it wouldn't have been an abuse of discretion for the trial court to have granted a continuance and you're giving your client release in this case. Do you think you can still win this case, even if I think that? Or do you think because there's more here that somehow changes the analysis? Or do you think that logically speaking, you can't win this case unless it would have been an abuse of discretion to grant a continuance and release your client?
The former option, Your Honor. We think even if you are not persuaded that it would have been an abuse of her discretion to grant the continuance, you know, if she released Mr. Workman or what have you, we think we can still prevail because the issue
And
here.
let me just ask you, I'll tell you why that seems hard to me intuitively, but I don't want to interrupt you telling me why, but let me just tell you, as you try to address it, why I'm struggling with that. Because if it wouldn't have been an abuse of discretion for the judge to say, I'm granting this continuance, but I'm going to release Mr. Workman in the interval in this case. If that wouldn't have been an abuse of discretion, I have a hard time figuring out how it could be an abuse of discretion to do something that is more favorable to him, at least if he's not objecting to it. And maybe that's where you're going to go. But if he's not objecting to it, it seems more favorable to him because then all of that happens, plus the government would have to go re-indict. Now, I get maybe in a case where he said, Your Honor, I don't want that. That's a ridiculous outcome. I want to go to trial today. And I'm ready to go to trial today, and I object to any delay of this trial. Then maybe it's possible that, but even then, is that would suggest if the judge could say, sorry, I would grant a continuance, but instead I'm going to be nicer to you and grant a continuance and grant your release in this case, and not just sort of on PR, but I'm going to dismiss this case. So this case can't operate to hold you anywhere. If I have a hard time understanding how, if one isn't an abuse of discretion, the thing that is, more favorable to the defendant would be. So can you try to, when you're explaining why you think, there's room in between those two things, try to address that aspect of it, which is particularly troubling me.
Certainly, Your Honor. And I will try my best. I think so one of the principles that Your Honor already articulated, and you are, you're absolutely correct that a part of this has to do with the defendant's objection and the defendant's ability to insist upon the trial date and his, it's sort of not for the court to jump in and say, well, I think this is more favorable to you, so I'm going to tell you that we were going to give the government more time, even though they've violated Rule 16, and even though I've already ruled that no continuance will be granted, we're still going to give them more time, even though these are circumstances where I've indicated that it's appropriate to hold the government to this discovery violation. That was the government's position below. Mr. Workman has no right to insist upon his trial date. Mr. Workman only has the right to accept what we give him, which is to say a continuance where one has been effectively denied, or an effective continuance where one has actually been denied. The other issue is this is not about favoring or disfavoring Mr. Workman. The principle that the government is not allowed to indict, dismiss, and re-indict to escape the position of disadvantage in which it found itself by its own election is about promoting respect for the entirety of the rules of criminal procedure and the entirety of the trial court's rulings and authority to make those rulings. And so when we have these cases, which we've cited to you, Pitts from the District of DC, Price from the High Court in Maryland, Hayden, which talked about this specific scenario in the Ninth Circuit, what those courts are referring to is that the government can't just do as it wishes with respect to these kinds of continuance rulings and these kinds of sanctions when it comes to preparing their cases. And
Can I ask you about that? It stated that broadly, I get puzzled again. This is a paraphrase, so correct me if it's not an accurate paraphrase, but I take your argument to be something like, if the government moves to dismiss a pending case and says, I want to dismissal without prejudice because something's not right now, I'm not ready right now to go ahead with this case. But I want it without prejudice because I hope that I will be ready coming, the government will be ready down the road. If the government isn't allowed to do that, if that's harassment by definition, because the government doesn't like its current situation, would prefer dismissal and the possibility of rebringing under better circumstances, if that by itself is harassment, then aren't all government dismissals without prejudice intrinsically harassing? Because why else would the government seek a dismissal without prejudice, except because it doesn't want to, it doesn't want the case to be pending right now, and it wants to leave open the opportunity that things will change to its strategic benefit in order to resume later. It seems like the idea that as broadly as you're characterizing it, it seems to practically mean that really there should never be the court should never grant a government requested dismissal without prejudice because they're all intrinsically harassing.
I don't think we've gone that far. I don't think that's where our position leads you. I think you have cases which the government has cited where they are waiting, if new evidence walks in off the street, if they're trying to supersede, if somebody all of a sudden decides to cooperate, and it's not as though the government has been sitting on that the entire time and deployed it strategically in order to get around some ruling or other circumstance that it doesn't like, those would appear to be perfectly valid reasons to dismiss without prejudice and rebring. I don't think our position.
To me that you've at times framed your rule too broadly, because all of those are examples where the government is saying we'd like to dismiss because we're not ideally situated right now. We hope we will be down the road. And so it's got to be something more than just this is a dismissal with a prospect of re-indictment if things are to the government's tactical advantage. It's got to be something worse than that. It's got to be like an end run around a ruling, which we've discussed a little bit already, or bad faith, which does figure in a number of the cases. And there's a dispute between the parties about its relevance or significance. But it seems like it seems to me, but your answer just a second ago indicates that it's overbroad to say it's intrinsically harassing if the government says, Judge, we're not in a good place right now. Dismiss without prejudice. We hope things will get better and we'll gear up again if they do. That seems overbroad, at least by the answer you just gave a minute ago, seeming to acknowledge that sometimes that's okay if there aren't worse things happening.
I would agree with that, Your Honor. But again, I think we, in this particular case, are very much in the end run around a ruling category.
I guess I have a question for why you think that. My impression is that the trial judge, when she dismissed the case without prejudice, was thinking that this will give the defendant the time the defendant needs to prepare in response to this DNA evidence. But for the fact that he had been detained, she would, and her concern, I think she wasn't really thinking this through all that clearly, frankly, but she was concerned because of the fact that he was detained, that a mere continuance wouldn't give him all the relief she wanted to give him. But if counsel had said at that time, Your Honor, we're here for trial. We're ready to go to trial. We want you to dismiss this case with prejudice. Then the judge would have said, no, I'm not going to do that. You get all the prejudice to you that's flowing here will be resolved if we just give you a little more time to review the evidence that the government has produced, belatedly, but they've produced it. So it seems odd to me to think that something nefarious going on here.
So the first point, Your Honor, is that counsel and the record of the March 3rd hearing amply supports that counsel was here saying, we're here for trial, whatever else was said.
I don't think she did that. I frankly don't think she did that. What she should have said, if she really wanted to push the issue, was to say, we're here for trial, we're ready, and then panel a jury, and let the prosecutor then say that they're not ready to proceed so that we can get a dismissal with prejudice. Or if you think that's a little unduly cumbersome, Your Honor, we move for dismissal with prejudice now because we're ready for trial. But counsel did not take that position.
Your Honor, what I'm referring to specifically is at trial call when counsel was asked if you are ready for trial. She said, yes, we are ready, but for the government's attempt to introduce this DNA evidence at the 11th hour, which I just got on, last Friday.
Right. Everybody agreed that was a problem and the defense was entitled to have some appropriate relief from that problem.
But I suppose insofar as Your Honor is suggesting that there was some reticence to go to trial, there was none. And I guess that's my only real point. Mr. Workman was ready to meet his charges, and it seems that the government was ready too. After the trial court ruled that the evidence would not come in and that the case would not be continued, there was an extended discussion of how they would bifurcate things, what the charges, what the jury instructions would look like. and further issues related to.
That's why it's so striking to me that the defense did not ask that the dismissal be with prejudice.
And so again,
or to say judge, and panel, and jury. They wouldn't go that far, but
with respect, we believe
let's let jeopardy attach.
We believe the government has waived this entire category of issues based on its response to Mr. Workman's motion to dismiss with prejudice.
You may be right about that, but my point is that when we're talking about whether there was bad faith here and harassment, all those things seem to me significant. Because what the government says, we're not harassing, we're doing just what was contemplated at the time for the defendant's own protection.
I take issue, Mr. Workman disputes the characterization of the record that would have him sort of complicit in all of this. Even if you're saying the government was proposing to do one thing and the trial court understood doing that one thing, Mr. Workman wasn't along for the ride willingly. When the government said, we are no longer ready to proceed, the die had been cast, the case was not going to go to trial, there was nothing that the trial court could have done or that Mr. Workman could have asked for the court to do, and I apologize for not mentioning this sooner, to compel the government to begin the trial. That is these separation of powers cases that the government has cited in its own brief, which we've also cited. It's not the court's place to tell the government begin the trial. That's not.
You're right. That's actually a really interesting topic, and I don't know that we need to get into it. But just one observation first. One thing that the defense could have done is to have said, we want a dismissal with prejudice. That objection easily, there was no impediment to making that objection clearly, rather than saying thank you when the court granted a dismissal that didn't say the word prejudice and therefore wasn't a dismissal with prejudice. But back on, I think you're right that the trial judge can't order the prosecutor to prosecute. What's less clear, and Judge Glickman's question suggested this, is whether if a case is called on a given day for trial, and the prosecutor is there, and the defense attorney is there, and the government says we're not ready, and we want a continuance, and the defense says we're ready, and we would like to start the trial, and the judge says motion for continuance denied, and then the judge says to the government, well, do you have some kind of motion? And the government says no, you've denied our motion for a continuance and we're not ready. And the judge says, well, I'm starting the trial today. I've just denied your continuance. You can participate in the trial or not. You're here. I'm starting the trial. I'm calling for a witness. We've got a defense attorney. You can voluntarily absent yourself from the trial if you want. And we'll see what happens then. And if I start a trial and I pick a jury and you don't introduce any evidence, I'm going to grant a motion for judgment of acquittal because there won't be any evidence. And that'll terminate this prosecution. It's actually very unclear to me whether that can or can't be done. I'd be interested in knowing what the United States thinks about that. But you think the trial court can't do that either?
Frankly, Your Honor, I've never encountered authority to support that. I don't, but I do believe that such an issue, such a possibility, insofar as it bears on the outcome in this case, has been waived. This is the first we've sort of.
That's a fair point. But I don't think the United States has contested that there was another option. That the option I was just describing is available. So I take your point that the answer to the question I have, though, may or may not be interesting. It may not be an appropriate way of resolving this case adversely to your client. I take that point. I was just curious whether your position really is that can't be done. The trial court had no option other than to essentially grant an implicit motion to dismiss with or without prejudice. And I gather you're not sure. It sounds like fairly enough, because no one's raised this idea before. You're not sure what the answer is to the question of whether the trial court can essentially start the trial without the participation of a prosecutor who was given a notice that the trial was going to start and doesn't ask for any relief and refuses, says, I don't have a motion. I'm just not going to participate in the trial.
You have correctly captured my impression of your question.
Okay, well, let us do this. Let us hear from the government and we'll give you reasonable time for rebuttal. Ms. Carroll?
Sorry, Your Honor, I had to make sure I was unmuted. May it please the court, Ann Carroll for the United States. Addressing some of the court's questions, first of all, let me say that the Judge McKenna certainly did not abuse her discretion in opting for a dismissal without prejudice. And she did explicitly make it without prejudice at the time on March 3rd, and explicitly denied the motion to continue based on the defendant's detention. So Judge McKenna was properly trying to balance the considerations of the government's need for evidence and the defendant's desire to not be detained any further. I would address Judge McLeese's question earlier about whether or not Judge McKenna could have granted the continuance. And under 1322H, of course, there was a basis for the court to grant the continuance on a finding of good cause. And one of the circumstances is the need for DNA evidence. And certainly in a 100-day case, it is routine in Superior Court that we won't necessarily have all the evidence in time for the 100th day if it's a particularly complex case, if there's the need for forensic testing. And the statute does provide a mechanism for an extension of that time. The circumstances we found ourselves in this case, however, because of defense counsel's and the court's schedule, we had already been beyond the 100-day. And so Judge McKenna reasonably denied the continuance, but was not foreclosing the possibility of the case being rebrought. And frankly, the government could have sought to release the hold in that case and sought a continuance outside of the 100-day statute and time deadlines. And it being a first trial date, Judge McKenna could reasonably have accommodated both the defendant's need for additional time and and thereby releasing him in order to relieve him of the burden of continued detention. However, the prosecutor very, properly brought to the court's attention that the defendant might still be detained based on the parole hold, and therefore did not opt for that course of action. But that was always clear to the parties at the time of the dismissal without prejudice, that the government could and likely would rebring the case at a later date. And indeed, it was appellant's understanding that by doing so at that later date, the DNA evidence would be admitted at a trial later, because that was never raised by the defendant as even a possibility. That the understanding had been that the only reason the court excluded the DNA evidence was because of the timing and the detention of the defendant. I would submit this case is actually very close to the facts that presented the court in Mann, which was cited by appellant, which was a 1972, I may be wrong. But in Mann, the government had lost a document that was needed for trial and had noted that it wasn't prepared to go forward. But the defendant had been detained because he at that point had not been able to make bond. And the circuit court specifically noted, I'm sorry, it couldn't have been 1972. It was before MAP, I believe. But the circuit court specifically noted that it was very reasonable for the trial court to consider the defendant's continued detention and opt to dismiss without prejudice in order to relieve the defendant of detention and allow the government to rebring the case when it had its evidence.
Appellant's argument here is that this is distinguishable because this is what appellant has called circumventing a court ruling, namely a ruling that precludes the government from using the expert testimony and DNA evidence at trial.
However, that was never the understanding of any of the parties, that this was a ruling in perpetuity, as it were.
How do we know that was never the understanding of any of the parties, that this was a ruling in perpetuity?
Well, first of all, the trial court made clear that the only reason it was denying the motion to continue was because of the defendant's detention. And the defendant, when he filed his motion to dismiss the second indictment, his motion in itself presumed that the DNA evidence would be admitted at a retrial. None of the parties even questioned that the DNA evidence would be admitted. That was certainly the understanding of the trial court, defendant.
But doesn't the transcript make clear that the court meant to sanction the government by ruling that the evidence would not be admitted? I mean, there was a sanction rationale for it, not just a defendant is detained rationale.
I would respectfully disagree, Your Honor. It was certainly the court's sanction was it had to exclude the evidence because it wouldn't have provided the defendant with sufficient time to meet that evidence. And the court specifically stated, I would grant a continuance, but for the defendant's detention. So it was made clear by the court that the reason for the sanction, and again, as I mentioned, this was the first trial date. Routinely, you would get a continuance for the need to obtain either the completion of DNA testing or if there wasn't sufficient time for the defendant to be prepared to respond to the DNA testing because it came too close to that first trial date. I mean, this is incorporated in 1322H. It was the unique circumstances of this case where, because of the defense and the court's schedules, this had already gone beyond the 100-day, and the court was unwilling to grant a further continuance.
Well, you're leaving out the other relevant feature of this case was that in the trial court's, to my mind, quite reasonable view, the reason that the DNA evidence wasn't available and earlier, and therefore that the trial date that was set couldn't be met, was because the prosecution had failed to, in a timely and reasonable way, secure those results and make them available to the defense. So you're kind of leaving out the other feature of the case that the trial court was relying heavily on.
The court did bend over backwards to say that this particular prosecutor was not at fault, but that the government was at fault.
And at best, what the court was noting was negligence on the part of the prior prosecutor, because the prior prosecutor had no, her failure to submit the DNA testing was her belief that there was no warrant supporting the collection of the buccal swab. And the court's response was, there had been probable cause, and essentially the prosecutor's heart may have been in the right place, but that wasn't a good enough reason. So essentially the court was recognizing negligence. But even in the cases, and I would note there are a couple of cases, this court has never held any reason other than speedy trial for 48B dismissal with prejudice. There has been some
discussion. Why are we talking about 48B?
Because this was a motion by the defendant.
Well, that gets us into some procedural questions we haven't touched on yet that maybe it'd be, if you want to try to, weigh into them. But before you start talking about 48B, we should talk about this. And your opponent's argument, as I understand it, is they, in their motion to dismiss after reindictment, they have a part of their filing where they say, this is effectively a government motion. And so it should be analyzed under 48A2. And then they say, the United States files a response, and the United States' response doesn't dispute that in effect it's a government motion, doesn't say, no, this should be a 48B2 case, doesn't dispute their reliance on 48A cases, and then just to finish their, what they rely on. And then the trial court, having had that briefing, says this is a government motion. And your opponent's point is this court is a little bit late, or a lot late, to be coming in and saying, no, that's all wrong. What really happened was that it was formally and, should be treated legally as a defense motion analyzed under 48B2. And I will say on its face that seems like a pretty persuasive set of points, and a set of points that usually the United States is deploying in its arguments as an appellee. So I'm interested in where you think that argument goes wrong.
Well, first of all, defense counsel did not tee this up as a government motion to dismiss in its pleadings. It cited Rule 48 and it cited cases.
No, there's an express. I mean, I don't have it in front of me, but I believe, and we'll see. Maybe Mr. Collins can get it in his reply, but I believe there's an express statement that says in effect, this was a government motion. Am I mistaken about that?
It acknowledged that the defendant had moved to dismiss. It did acknowledge that, but it did not ask the court.
No, I asked you one question, you answered a different one. So if we can slow down. I am recalling, though I don't have it in front of me for technical reasons, because the court doesn't have its internet. I'm recalling that in the opposition, there's an explicit statement where the defense says, I'm paraphrasing this now, but essentially says, this is in substance a government motion. Are you saying that was never said? Nothing like that was said? Because you started talking about else, but.
My recollection of the defense motion was that it did not raise this as a decision for the court under 48A.
You keep not answering my question and saying something different. What's your belief about whether they say something like what I just said?
What they said was that even though the defense moved for a motion to dismiss, this was, for all intents and purposes, a government motion without citation to any authority and without requesting that the court address that point. The government's response.
I thought generally, if you make a point, that was an implicit request that the court address it if your opponent disputes it. I mean, filings would look pretty funny if, after each point, somebody said, and by the way, I hereby request the court address this argument.
Well, as Your Honor might know from prior Superior Court practice, often practice in Superior Court does focus on the merits rather than the procedure in many instances. And the government's pleadings in Superior Court are never with the kind of precision as an appellate brief would be. But for even appellants' arguments of waiver, citation to cases such as Wood and Rose would not find waiver in this instance. Wood, for instance, explicitly said waiver is an intentional relinquishment of known right, not inadvertent error. In fact, in Wood, the issue was that the government had explicitly recognized a statute of limitations issue and chose not to assert it in the trial court, and found that the circuit court had abused its discretion in resolving based on that statute of limitations issue.
Leave aside the word waiver. How about the word forfeiture or failure, or the phrase failure to preserve for purposes of appellate review?
Even in this court's case, Rose, also cited by the appellant, excuse me. The court's characterization of waiver or forfeiture has been, had it not been raised in the government's brief. Rose involved, the first time it was raised was in an oral argument, not raised in the government's brif.
Well, leave aside what the government's, leave aside what the particular cases cited by Mr. Workman in his briefs in this court and how you might distinguish them. I mean, do you dispute that, at least ordinarily, if a defendant makes an argument and the trial court and the United States files a brief in opposition, filing in opposition in the trial court, and doesn't dispute that, and the trial court accepts it as a basis for ruling, that ordinarily this court wouldn't, would treat as failure, as inadequately preserved an argument by the government that, actually, the trial court erred in accepting this argument by my opponent that I didn't oppose. Do you dispute that general proposition?
I don't know. I won't dispute the factual to some extent.
There are no facts. My question is not about any facts in this case. My question is, do you dispute the following abstract proposition? If a defendant adequately makes an argument in the trial court, the government does not respond or oppose it, and the trial court rules in the defendant's favor, that ordinarily this court will not consider an argument made by the United States for the first time in this court that the trial court was wrong in accepting an argument that the defendant made and was not contested. That has nothing to do with this case, you may think, as it is an abstract question of law about what this court normally, when this court treats arguments as adequately preserved.
I do think that
general proposition?
For instance, a failure to object, I agree. A failure to object would failure to preserve an argument for review on appeal. I think where I continue to try and bring us back to this case is, one, that wasn't the basis of this court's ruling, and two, it's different. I'm
sorry, when you say this court, do you mean the trial court?
The trial court. I'm sorry. Judge McKenna didn't rely on whether it was a government or a defense motion. But in the second instance, I think it's different when it is the proponent, the appellant, who is articulating the basis for a reversal of a ruling, whereas the government citing alternative basis for that supports a trial court's decision. And in this case, as this court held in evidence, where there are alternative bases that support a decision that was not addressed by the trial court, this court certainly can rely on that basis.
There
So in
is
that
authority. There is authority for the proposition that the decision of the trial court can be affirmed on any ground, even if it was not even raised below, provided there is no unfairness to the opposing party in the appellate court's consideration of that ground, and especially, or perhaps only, where it's a pure question of law. And so you do have that possible out here. It's a little unclear to me whether that applies, but if presumably, if it matters whether we view this under the prism of Rule 48A or Rule 48B, that would presumably be the response you would make. And I think you did include something like that in your brief.
Yes, Your Honor. In addition, unless there are further questions on that, I did want to address some of the questions the court raised. First, that to the extent that there is any allegation, the defendant has not established any actual presence, even if the court were to consider this under 48A. Appellant has overbroadly read those 48A cases. This court has not addressed 48A in the context of denial of a motion to dismiss without prejudice. However, the cases cited by appellant, first of all, the Maryland case that was interpreting the Speedy Trial Act and rules in Maryland certainly has no bearing on interpretation of Rule 48A or B. And therefore, appellant's reliance on Price and all of the Maryland cases are just totally distinguishable. This court analyzing Rule 48A or 48B has looked to the federal counterpart of Rule 48 in evaluating how to interpret those rules. And in respect to each court that has addressed it, the court has found exclusion or suppression of evidence is a reasonable basis for the dismissal without prejudice, so that the government can rebring the case.
I think it depends on why. I think it may depend a little bit on why the evidence is being excluded or suppressed. Here, it can be argued that, look, the evidence is being excluded because of government malfeasance. It may be only negligence, but it was the government's fault. They knew they were under tremendous time pressure to bring this case to trial. Everybody's gotten themselves ready for trial on this date. And now the government comes in at the last minute and says, we were very tardy, forgive us, and let's just have a continuance. And the court says, well, I'm not going to forgive you. We're going to suppress this evidence. And the government says, oh, well, in that case, since you're going to suppress the evidence, we're just not ready to go to trial. Implicitly saying, we'd like a dismissal without prejudice. You can understand why the defense would be saying, well, that's just really nice. You're just using the dismissal without prejudice to get around the sanction that the court has otherwise imposed on you for your tardiness. And we think that is the kind of thing that rises to the level of, call it what you will, harassment of the defense. We are ready for trial. Now, how do you respond to that?
Two answers. First of all, as Your Honor recognized, appellant did not object to a dismissal without prejudice or with prejudice. Appellant's counsel requested the dismissal.
This is one of those cases where both sides failed to do a lot of things they could have done. So the government could have raised 48B and the government could have, everybody.
But in order
And-
to, but in order to reverse Judge McKenna's ruling, appellant certainly should have objected to a dismissal without prejudice.
Well,
Or said,
Maybe so, but your opponent argues that you essentially waived that argument too, or failed to preserve it. Waiver is probably an imprecise term there, although we use it in our cases sometimes in the expression waive the waiver. But it is, Judge Glickman raised a point early on, an argument about whether the United States could have argued in its brief in this court or in its filing in the trial court opposing the motion to dismiss after re-indictment, could have made the following point. The defendant is here complaining essentially that you erred, trial judge, in granting a dismissal without prejudice. And in substance, their argument is you should have granted a dismissal with prejudice. They should not be heard on that argument because they did not object at the right time. The time to make that objection would have been when you were ruling. And I didn't see that argument made as a procedural default failure to preserve argument either in the trial court in the government's opposition or in the government's brief in this court. I mean, the government does kind of make the point that there was no objection as it relates to kind of the bad faith or other inquiry. But don't even consider this Court of Appeals. This argument was not properly preserved by the defense because of the failure to object at the time of the dismissal. I didn't see that argument either in the trial court or in your brief in this court. Am I missing?
No, Your Honor is correct. We did not make that procedural argument, but we did make the argument that the defendant cannot fail to object to a dismissal and then appeal that dismissal without prejudice, saying that it should have been granted with prejudice. So we did raise it in the context of the substantive argument that the appellant cannot come in now and complain about the dismissal when he agreed to the dismissal. In fact, it was on his motion. So what the courts that have analyzed 48A cases, even Rinaldi, the clause omitted from the quotation in appellant's brief says upon objection of the defendant. So if the defendant objects to a dismissal, then the court must consider whether or not there's bad faith in the dismissal of the case, and whether or not it should be granted, or in determining whether or not it should be granted. But in addition, the harassment allegation, appellant has not established any actual prejudice or harassment of the kind that has been found to have justified a with prejudice dismissal in any federal case. None of the cases cited by appellant interpreting Rule 48 have held circumstances of this case would have warranted a finding of actual prejudice or prosecutorial harassment. And indeed, appellant says that prosecutorial, the bad faith is irrelevant. And in fact, has been held to have been relevant where there hasn't been a showing of actual prejudice. But I think the appellant relies primarily on Poindexter. Even in Poindexter and Borges, the prosecutorial harassment was the vague expectation of potentially being able to re-prosecute once the essential witness was rehabilitated or the need for classified evidence wasn't needed. And a significant factor for Poindexter, the judge in Poindexter, was the fact that the government was seeking to dismiss only some counts of an indictment and not seeking to dismiss the entire indictment, and seeking to prosecute that remaining count, and then at some point potentially rebring those additional counts. Each case that has addressed it has held it has to be exceptional circumstances that would warrant a with prejudice dismissal. We do not have those circumstances here. As Judge McKenna, and certainly we do not have the circumstances where Judge McKenna's analysis could be held to have been an abuse of discretion. And we cited Bernal, which was a case that did not involve a dismissal, but it did involve DNA evidence, where the court, DNA evidence and a continuance, frankly, not based on the need for DNA evidence, but on a late disclosure of a defense expert, which also permitted the government to obtain an expedited DNA testing where the previous testing had been excluded. This court recognized that where the trial court engages in the weighing of the considerations, the factors, of denying the motion or proceeding, was within the court's supervisory powers and could not be deemed an abuse of discretion. Judge McKenna explicitly declined to explicitly granted a dismissal without prejudice. This was after the defendant's counsel had raised the possibility of there being a retrial or rebring. And Judge McKenna explicitly told prosecutor not to respond to it because the circumstances of this case make clear Judge McKenna was doing the same thing that the judge in the Mann case, which was 1962, the Mann case found appropriate. That is, the detention of the defendant was a factor to be considered in whether or not to dismiss without prejudice and permit the government to rebring the case. That is exactly the facts we have here. There has been no case cited by appellant where Judge McKenna's action has been held to have been an abuse of discretion. Indeed, there have been cases where this court has repeatedly held dismissal with prejudice is an abuse of discretion, such as Stevenson, Mack, Cruz, a number of cases where this court has touched on the circumstances that would warrant with prejudice dismissal. And in each case, the court noted it cannot be arbitrary or capricious or unless there is a speedy trial finding. In this case, there's certainly no question of a constitutional violation of speedy trial right. An appellant, I would also note, does not assert any actual prejudice. To the extent that there's any discussion of prejudice in the good faith or bad faith in the context of 48B, there's been some cases, for instance, Hattrup and Goodson, where there has been some discussion of 48B, an abuse of discretion to dismiss with prejudice, where there's an absence of prosecutorial misconduct and demonstrable prejudice or substantial threat thereof. So we would submit that even in the context of arguing on a prosecutorial harassment, this would not fit in that context. This was early on in the case. This is not a situation where, for instance, there had been a trial, a mistrial, multiple rebrings of a case, and there's no case cited by appellant that has held an abuse of discretion under the facts of this case. I fear I'm repeating myself. If there are no further questions, Your Honors, we submit that there was no abuse of discretion and this court should affirm the decision, the appellant's conviction.
Thank you. Mr. Collins, let's give you 5 minutes or so for rebuttal.
Thank you, Your Honors. And so the first point I would like to make in rebuttal is just that the government below knowingly positioned itself for ruling on the merits of the Rule 48A2 issue. There's no wiggle room there. As Your Honor, as Judge McLeese mentioned, at page 5 of Mr. Workman's motion to dismiss with prejudice, there is a very explicit argument that the government, even though it did not move expressly to dismiss without prejudice, for all intents and purposes, that is precisely what it did by declaring that it was not ready to proceed in response to the court excluding DNA expert testimony. That's a verbatim line. The government, in response to that argument, embraced the Rule 48A prism and proceeded to try to distinguish its conduct in this case from the conduct which had been presented in the cases that Mr. Workman cited. And we believe that constitutes a waiver. And I would add, the government raises this potential of, or it seeks to distinguish certain cases that Mr. Workman has cited by arguing that this was inadvertent. As we've noted, this was the same prosecutor who was present at both hearings, and there was an apparent strategic interest in securing a ruling from a Superior Court judge that this was something that it was allowed to do under Rule 48A2. It certainly, they are a repeat player in the Superior Court. They are the felony prosecutor, the predominant felony prosecutor. And having a clear ruling on this, that they could do it under Rule 48A2 over defense objection, no matter what, was in their interest. And so this is not something that was inadvertent. This was something we submit that was apparently purposeful and knowing on their part.
If I may ask, how do you respond to that general proposition that trial court rulings can be affirmed even on grounds not raised, not properly preserved in the trial court, even on grounds that are, first arise on appeal, where there's no procedural unfairness to the opposing party, and particularly where it's a pure question of law. In other words, accepting, as you say, that in the trial court, the government never mentioned Rule 48B and treated this as a Rule 48A question. For the first time on appeal, they say, hey, wait a minute, this is actually 48B and the standards are different and they can't win under those standards. Why is it that that proposition I mentioned doesn't come to the government's aid in this case?
Certainly, Your Honor. So we've seen this court. It's the law of the DC Court of Appeals as far sorry, and I apologize for just cutting off my statements, but Judge McLeese mentioned the doctrine of waiver of the waiver, which this court has fully embraced in cases such as Wilson Bay and Carroll, the en banc opinion in Carroll. These forfeiture and waiver arguments, which sound in equity, it has been the practice of this court to hold the government to its waivers in the trial court when the issue is whether the defense has presented these or has made its objections in a sufficient manner. And so I submit this case is one that is ripe for a waiver, a government forfeiture, for lack of a better term. And because it does not appear to be inadvertent, and there are ample strategic reasons that appear on the record. In addition, I would like to just go back to this notion that the trial court, Judge McKenna, could have reconsidered her continuance ruling, and so therefore Mr. Workman's appeal has no merit. As I've said, the court doesn't need to conclude that she would have abused her discretion by doing that or by releasing him. But Your Honors, we don't believe essentially that's what she was doing. She didn't revisit her ruling or her sanction. In our view, if she had inquired of the government, why are you moving to dismiss? And if they said, because we don't like the continuance and the sanctions denial, so we're going to rebring the case without those impediments, that would have been a basis for dismissal with prejudice. We agree. Excuse me, the fact that the dismissal could have been for a legitimate reason, going to taking an appeal or finding new evidence that would support the same proposition, I think that makes dismissal without prejudice at the time okay. But when they rebring it and give their reasons, then the dismissal becomes inappropriate. In other words, we've seen in cases, Salinas is one that we cited in our brief, where the government gives a sort of a general justification for dismissing with prejudice. We're going to seek a superseding indictment. Further inquiry is had at when the case is rebrought under a new indictment, and then the government's reasons are shown up as inappropriate, which in that case was we didn't like the.
Well, here the government said, look, we're not ready. And the reason we're not ready, they mentioned the fact that at the moment we also don't have this evidence, but that wasn't the real reason. The reason we're not ready is because you're telling us we can't introduce the testimony of our DNA expert. And so they said that at the outset. It's not like they've really changed their reason. or held or concealed their reason for seeking a dismissal. If we posit, this is what's so artificial about this case, that the government sought the dismissal, but so I don't know that this really comes into the category of the government hiding the ball when they first got the dismissal without prejudice, and then the real reason comes out in some way later on, which is the paradigm I understood you to be describing.
We believe there is a common thread through this case in Salinas, which was that it wasn't firmly established. And we haven't heard the government say the government hasn't in this case volunteered to say every time there is a dismissal without prejudice, we will give all of our reasons and there will be a thorough inquiry, and that's what should be the law of the land. We've, in multiple cases that we cite, both Salinas and I think also Price, there is this further inquiry when the case is reindicted, where it's a better opportunity to plumb the actual circumstances. And so with that said, if there are no further questions, we would ask that you reverse Mr. Workman's conviction.
Counsel, thank you very much. The case is now submitted, and I can excuse you and you can log off.
Thank you, Your Honor. Have a good day.
This honorable court is now adjourned.